Hello, court officer. Hello, court officer. Hello, court officer. Hello, court officer.
ಮೇಡಮ್ ಹೇಳಿ.
Audible ಇದೀನಾ ಅಂತ ಚೆಕ್ ಮಾಡಕ್ಕೆ. Thank you.
ಸ್ವಲ್ಪ ಕಮ್ಮಿ ಅನಿಸ್ತಾ ಇದೆ ಫೀಸ್.
ಹೌದು, ಸ್ವಲ್ಪ ನೆಟ್ವರ್ಕ್ ಇಶ್ಯೂ ಅನಿಸ್ತಾ ಇದೆ.
ನಮ್ಮದು ಕರೆಕ್ಟ್ ಆಗಿದೆ ಮೇಡಮ್.
ಮ್ಯಾಮ್, ಪೇಜ್ ವೈಸ್ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್.
ಹೌದು.
ಥ್ಯಾಂಕ್ ಯು.
Without intimation,
ಚೀನ್ ಅಂದ್ರೆ ಇನ್ನೊಂದು ರೆಸಿಡೆನ್ಸ್ ಸಿಕ್ಕಿದೆ. Administrative function, you are not a tenant.
No, he is there from that 6 months. He is there.
Serve it on Mr. Pawan. These are all administrative acts. Somvara ಬರುತ್ತೆ. Tomorrow only you have to come. We won't come. Only you come and argue. Nothing for today, Alva. ಏನಕ್ಕೆ end of the list?
Demanding to pay the property tax when education is as there are two judgments of your lordship.
It will come on Monday. There is no urgency. Yes. Next week, yeah. ಕೊಡಿ ಮಂಡೇ ಎಲ್ಲ ಕೊಡಿ, ಮಂಡೇ ಟ್ಯೂಸ್ಡೇ ಕೊಡಿ, ಅದ್ ನೋಡ್ಕೊಂಡು ಇದು ಮಾಡ್ಬೇಕು. ಎಂಡ್ ಆಫ್ ದಿ ಲಿಸ್ಟ್ ಏನು? Who is planning to demolish? Why are they demolishing? You have constructed.
Yes,
Which panchayat is it? Which panchayat? Yeah, find out ಮಾಡಿ ಸರ್ವ್ ಮಾಡಿಬಿಟ್ಟು end of the list. Nothing for today. It will come next Monday, Tuesday, Bharat. Only end of the list.
Date number 7, serial number 45. Date number 8, serial number 46 to 51.
49.
Have you informed the other side? 2015 matter, Mr. Counsel. 49 at the request of counsel for the petitioner released on 8 November. If arguments are not advanced on that date, petition will be live to be discussed, non-possible. Yes. Today morning? You are for whom? Have you informed the respondent?
46 serial number.
You for whom? ನೀವ್ ಯಾರಿಗೆ?
Here for the
Have you informed the respondents ಅಂದ್ರೆ ನೀವು ಹೂ ಅಂತೀರಾ? ನೀವು ಯಾರು ಅಂದ್ರೆ petitioner ಅಂತೀರಾ? Have you informed the respondents? Please wait.
serial number 15 memo for
Serial number
55
50. Counsel for the petitioner. Construction that. Now you have woken them up. Counsel for the petitioner has filed a memo dated 6/10/2023 signed by the petitioner and the counsel for the petitioner, seeking permission to withdraw the above petition. Accepting the said memo, the petition is dismissed as withdrawn.
Page number 9, serial number 52 to 60.
You are for the petitioner. We inform the respondent. Objections are filed, Mr. Akira Bedwa. Counsel for respondent number 1 and 3 submits that written statement of objections are not required. You will be addressing arguments on the basis of the records. That counsel for the Yav Taluk Panchayat idu. Who is respondent number 2? File ilva? At least have the file. Nodi Yav Panchayat so and so is directed to accept notice for respondent number 2. Counsel for the petitioner to serve 2 sets of the petition along with annexures on the said counsel. Relist on 10 November. Inform madidira. At the request of counsel for respondent number 1 and 2, relist on 8 November. Have you informed the respondent? 56 at the request of the counsel for the petitioner, relist on 10th November.
Page number 11, serial number
My lord, serial number 59, my lord. I'm appearing for the respondent number 2.
Serial number
59, my lord.
9. Yes.
For the respondent number 2, my lord, I seek 2 weeks time to file an objection. I have filed an wakalat in the counter, your lord.
Yes. Right, counsel for respondent number 2 seeks for and is finally granted 2 weeks time to file a statement of objection. Objections, if any, to be filed on or before 3rd November. Failing which should be taken as not filed. Relist on 8th November. Interim order earlier granted is extended till next date.
Grateful, your lord.
serial number 70 and for the respondent number
Serial number 70.
70 and for respondent number 2 and 3 for the petitioner also.
Yes. Yenake. You have filed your objections. 70 learned counsel for respondent number 2 and 3 seeks for and is granted 2 weeks time to address his argument as the arguing counsel is traveling. Relist on 7th November.
page number 12, serial number 75. Page number 13, serial number 76 to 79. Page number 14, serial number 80 to 87. Page number 15, serial number 88 to 97.
Serial number 90, your lordship. Kindly have it on Tuesday. I'll be reporting settlement on Tuesday. Your lordship. Serial number 90, your
Just a
lordship.
moment, please. 1 nimsha irri. 95. Counsel for the petitioner has filed a memo dated 6th October 2023 signed by the counsel for the petitioner, seeking permission to withdraw the above petition. Accepting the said memo and submission of the learned counsel for the petitioner, the petition is dismissed as withdrawn. Yes, madam, what is your number?
90, your lordship.
Huh?
Kindly have it on Tuesday. I'll be withdrawing the petition, your lordship.
90. Learned counsel for the petitioner requests for the matter to be taken up on 10 for purpose of withdrawal of the petition. Relist on 10.
Grateful, Your Lordship.
94. Have you informed the respondent? 94 at the request of the council for the petition relist on 7th November. 96. First. Objections are 96 at the request of both the councils. Relist on 8th November, interim order earlier granted is extended. You have not informed the other side. Please wait till it is called. He is the advocate for, he is your former advocate. To whom? Serial number 46. You appear for Ms. Vaishali Vigde. So who is seeking time? You are seeking. Yeah, no, confusion, no. You are seeking for time. You are also seeking for time. Both the counsel for the petitioner and respond number 5 seek for a short accommodation to get ready and address their arguments. Relist on 10th November.
Order serial number 1. Srinivasrao.
Yes. You received copy of, you have to file objection. You have filed objections. You have received. Yes. The criminal petition, you can't be asking for adjournment like that. We'll pass over that. Tomorrow you will have to come. It's a Saturday. At the request of the additional SPP released on 9th at 2:30 p.m. Interim order earlier granted is extended till next day.
Serial number 2. David Brahmo.
What is the objection? Amendment application copy not served. Somya ji, an amendment. What is the amendment you are seeking for? Chief Officer Pandavpura instead of Patna. Accepting the counsel for the petition has filed IA 1 of 23 for amendment. The office has raised objection as regards service of copy. Learned counsel for respondent confirms receipt thereof. The accepting the reasons stated in the application, the amendment being only as regards the description of the party, the petition and the amendment application is allowed. The IA number 1 of 23 is allowed. Counsel for the petitioner to carry out necessary amendment and file amended cause title. Pandavpura badlu ಇವಾಗ ಇದಾಗಿದೆ. ಏನು ಸೋಮೇಶ್ವರ? ಶ್ರೀರಂಗಪಟ್ಟಣ ಬದಲು ಪಾಂಡವಪುರ ಆಗಿದೆ. ಪಾಂಡವಪುರಗೂ ನೀವೇ ಅಪೇರ್ ಆಗ್ತಿರಲ್ಲ. ಅದು ಕರೆಕ್ಷನ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಪಾಂಡವ್. The first respondent, you have entered appearance for respondent number 2. First respondent you ಶ್ರೀರಂಗಪಟ್ಟಣ ಅಂತ ಮಾಡಿದ್ದಾರೆ. ಪಟ್ಟಣ ಪಂಚಾಯತ್. So ಯಾರು ಅಪೇರ್ ಆಗ್ತಾರೆ? TMC ನೀವು ಅಪೇರ್ ಆಗಲ್ಲ. ಯಾರಮ್ಮ? The GM Ananda is directed to accept notice for respondent number 1 and 2. Registry is that delete the name of Shri B.J. Somyaji as that appearing for respond number 2. Counsel for the petitioner to serve 2 sets of the petition along with annexures on the said counsel. 3 weeks time is granted for filing of objections if any by 10th November. Relist on 17th November.
Serial number 3. Decision and connected matter.
Please carry it out. Carry it out now. Pass out. Yes. So where is Mr. Badrinath? Yes. He was to go through it and make a submission.
This is with regard to Karnataka implementation, Board of Public Policy. Regard to reverse of.
You wanted to go through it to make a submission, whether it is in compliance with the NGT direction, time to only. Mursati Ajana Admel Bantala. He's not there today. You are appearing for Mr. Badrinath. Is he there today? Bandidara? Tell him that it's passed over.
Now the facility is connected matter.
Yes.
5.1 minutes.
8 month, 3 month, 20 month. This products, the proposed respondents products are the landowners products. In petition. Challenges.
Mr. Suman,
My lord, for Suman, my lord, for Suman, sir, my lord, we have already filed a memo of retirement, my lord. We have already handed over the files to the client as of 2/5/23, and we have also filed the memo of retirement in the matter, my lord. We don't have the files with us.
you are appearing for Mr. Siddharth Suman.
Yes, my lord. We have filed the matter.
You filed a memo of retirement.
Yes, my lord. Yes, my lord. My name is on the Vakal, my lord. Amok Mas. Along with acknowledgement from the client, we have filed we filed the memo, my lord. I pray it may be taken up.
5.1.
Yes,
The
ma'am.
petitioner has filed a memo of retirement dated 21/5/2023.
Yes, ma'am.
Enclosing therewith a letter of acknowledgement issued on behalf of the petitioner. Signed by its operations manager.
Yes.
Having confirmed receipt of all documents pertaining to the said writ petition along with the NOC Vakalatnama.
Yes, ma'am.
In view thereof, the memo of retirement is accepted. Shri Siddharth Suman is discharged from the matter. Registry is that print the name of the petitioner in the cause list.
Much more.
None appears for the no arrangements for representation has been made. Anybody is appearing for the petitioner? No appearance has been, no arrangement for representation has been made on behalf of the petitioner today. If none were to appear for the petitioner on the next date of hearing, the petition would be liable to be dismissed for non-prosecution. What about 5? There's some office objection on your application.
The application is filed by the respondent. The said application is now. That is for modification of the framework that was filed by the respondent. The alternate arrangements made and that part of time is being done. The application also.
Relist on 8th November.
Much obliged, madam.
Interim order earlier granted is extended till next.
Serial number 3. Serial number.
You are for whom? Impleading respondent. You have for respond number 4 to 6. Yes. Yes. Hmm. Yes. So. Hmm. Way this not just like you'll have to show us the plane. Have you filed it? Have you filed the plaint in the civil suit? Have you filed anything in this matter?
Last time bidding application allowed.
If it is allowed, then you are already on record, madam. IA 2 of 23 was your impleading application. It was allowed on 12/9. If you want to file something, please file it. Without filing, don't say something is there. We don't know until you show it to us. You may know. But until you give us the plaint or whatever that you want to file, we won't know. You have to carry out amendment. You have to file a affidavit.
With regard to that, what my fair submission when the concerned AW is a lady, she asked me to the spot, but the person who claimed that it is a sign, they try to threaten her and they are not allowing her to do. So what I have suggested you take police protection. They have already approached the police.
Who threatened your officer?
So claims it to be a sign they don't, because last time what
Who threatened your officer?
in my mind.
She should file a complaint.
Yes, sir. That's what I have asked her to take police protection. Kindly give us 1 week time. With the help of police, we will remove the. As far as my lordship have asked, what is the difference between the two
Mr.
photographs?
Pawan Kumar, an officer of the state is being threatened by somebody.
Yes, sir.
It's a very serious thing.
That's what-
You should go to them, they will take action.
Yes, sir. That's what I have instructed her. She has approached the police. But give me 1 week time. What I'm asking for, give me 1 week time. We will take police help and we will remove the.
The counsel for the petitioner seeks for and is granted a week's time to carry out the amendment. Learned counsel for respond number 2 and 3 submits that when the assistant executive engineer of
May not be.
being brought to our notice, we have to protect their interest.
Yes,
If
sir.
your officers get threatened by people,
Because they have said that now she will approach police and with the help of police, we will, because I also asked that.
we'll make note of it and we'll direct them also to take action.
Because today.
State is a party. You're a party. Police station will take action.
Police may be directed to the.
This is a rule of law. They have to abide by law. Just one. That counsel for respond number 2 and 3 submits that when the assistant executive engineer of respond number 2 and 2 had visited the property, she was threatened. And as such, she is in the process of filing a police complaint to take necessary action. Learned AGA who is present before this court.
Police complaint, she will take police help to and remove them. With the help of police protection, now we will,
Return ಮಾಡದೆ ಏನು ಮಾಡಲ್ಲ ನೀವು ಸುಮ್ಮನೆ ಇರ್ತೀರಾ.
because we don't know the name of the person.
Find out.
Police will invest.
We'll investigate. Learned AGA who is present before this court is directed to instruct the concerned police officers, police station to take the complaint on record and carry out necessary investigation. Learned counsel for respond number 4 to 6 seeks for and is granted 2 weeks time to file a statement of objections. And what is it your?
The beginning which is the,
Wait, Mr. Pawan Kumar. Right, counsel for the petitioner has filed a memo enclosing certain photographs. The same is taken on record. Released on 25th October. By 25th October, please take it.
the help of the.
Yes. And before that, you have to file, all of you have to file affidavit by your respective.
It is not there. It is the.
Nivilva.
Can you see the order? R5.
R5 ni yaar, who is R5?
The municipality.
You are not appearing.
No, I am appearing.
You are appearing. You don't need to.
Been asked by the-
You don't need to file affidavit. Ashte.
I'll be close to the.
For your Russia, I'm appearing the Russia.
R5 is there. R4.
R4, I am appearing. I'll appear to Russia. In the meanwhile, your Russia, what happened, the entire petition, your Russia. Though we have read as a party, Management Corporation is read as a party. The prayer which has sought your Russia only in respect of the Takala municipality. I don't know why it has made a corporation as a party, and as a party. But what's the prayer? Was a prayer?
This will become infrastructure. 2022. You are asking for the Tulsi Puja of the year 2022. Now we are in 23.
But it is for the next year also. Representation.
That is not there in this prayer.
Of course, election game not kindly.
For the next year, you'll have to give fresh representation.
Festival is started for this. You cannot cross any further representation and, but it is only for Deepavali and Procedural, not firecrackers being not.
What is your interest in this matter?
But I am one of the radar laws intending to participate in the allotment of stocks. But the corporation and the municipality having of the Gram Panchayat meetings do not allot the stock by way of letting it out instead of auctioning. But if the auctions are conducted to us, the panchayat and local bodies not will get more.
Who is to conduct the auction?
But 90 not annexure. There is one reference not annexure H-44.
Karkara
Annexure H was me page number 44.
44.
The second para.
Yes.
ಅದರಂತೆ ಉಲ್ಲೇಖ ಒಂದು ಮತ್ತು ಎರಡು ಅರ್ಜಿಯ ಪ್ರತಿಯನ್ನು ಏಕಪ್ರವೃತ್ತಿಯ ವ್ಯಕ್ತಿಗತ ಪ್ರತಿ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಪರಿಶೀಲಿಸಲಾಗಿ ನಗರ ಸ್ಥಳೀಯ ಸಂಸ್ಥೆ ಪ್ರಜಾ ಪರವನ್ನು ಬಾಕಿ ಮತ್ತು ವಿಲೇವಾರಿ ಮಾಡಲು ಯಾವುದೇ ಅವಕಾಶ ಇರುತ್ತಿಲ್ಲ. ಮಾನ್ಯ ಗೌರವಾನ್ವಿತ ಭಾರತ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯ ಹಾಗೂ ನ್ಯಾಯಾಲಯದ ಗೋಯೆನ್ಸು ಪ್ರಕಟ ತೀರ್ಪುಗಳಲ್ಲಿ ಕರ್ನಾಟಕ ಸುಪ್ರೀಂ ಕಾಯ್ದೆ 72 ಮಾಡಿ ಕ್ರಿಯಾಕರಿತ ತಾತ್ಕಾಲಿಕ ಹಾಗೂ ನಿರ್ದಿಷ್ಟವಾಗಿ ನೀಡುವುದು ಬೇರೆ ಕಾಲದಲ್ಲಿ ಆದೇಶ. ಆದ್ದರಿಂದ ಈ ನಿಯಮ ಮಾಡಿದ ನಿಯಮಾನುಸಾರ ಸೂಕ್ತ ಕ್ರಮಗಳಿಗೆ ಹಾಗೂ ಕಚೇರಿಗೆ ವರದಿ ಸಲ್ಲಿಸುತ್ತಿದೆ. We have also petition as also for. And earlier got the petition as supposed to some court in the year 2021. Some court was observed that the lag and not the petition as approached. Therefore, not that juncture the petition could not be retained. That is the finding of the some court on page number 45.
Yes.
The operative was not last paragraph as the process of public auction requires some time for filing application and process to be managed and by then before the to listen to the door. The purpose of allotting the space for shops is for selling matters and the system of keeping order which is scheduled to be held in this day and people to become installed. The very purpose for allotting the shops to become free. Therefore, the question is not available and the same is these observations
Now, who is to conduct the auction?
But municipal.
Which respondent, Mr. Prasad?
Plus respondent number 9.
Respondent number 9.
Respondent number 9.
So who is appearing for respondent? You are appearing for respondent.
Respondent number
So
9.
what are you proposing to do now, Mr. Ariga?
I propose to write an affidavit as per the direction of the-
That is another affidavit. Apart from that, as regards auction, what are you proposing to do now?
The auction has to be conducted.
You are proposing to conduct an auction.
I intended on inspection, but not that I inform them that there is a inspection.
Because this is for Deepavali, which is another month away.
That is the November.
Another October agoyt. Shuru aitu.
November 20th.
ಆಮೇಲೆ ನೀವು now it is too close, we can't take all this and last time ಹೇಳ್ಬಿಟ್ಟಿದ್ದೀರಾ.
Will not come. Because earlier institution was had become infectious. Now that it is only if at all prayer is to be.
We'll have it next week.
Please.
You get your instructions and make us, if you are going to hold the auction, then his grievance is answered. You file your affidavit also.
As far as responding number 11 is concerned,
Hmm.
that will not come into picture because it is not a public interest case. 11 is, there is not, cannot be specific direction. That
Yes.
will be
If you are going to make a submission that 9 is going to conduct it,
no, that's an inspection and through an affidavit.
but then this time lottery we won't permit.
I understand.
That can't be, that was only during COVID
Yes, because of the situation.
situation. Now auction, you have to get the best measure, best revenue for it. When will you get your instruction, make your submission?
Cannot, six, can it be on the 12th?
At the request of Shri K. Chandranath Ariga, where possible, respond number 9 and 11, we list on 12. In the meanwhile, affidavits to be filed and instruction to be obtained as regards whether an auction would be conducted and if so, when.
So far as 11 is concerned, they need not file an affidavit with my signature because it is confined only to my 11 responding number.
The affidavit has to be filed after service, they should appear. We are having a situation in all, especially this panchayats, though it is for self-governance, but they are served and nobody appears. I want to put them on notice that action will be taken if they don't appear. What is the purpose of issuing summons?
Yes.
Private parties meeting, government authorities and local government doesn't appear under.
Now they have posted on website who is very important.
Nodal officers and
Okay, posted on RTGL. Yes.
then there is submission made. Now only the TMCs and CMCs, Urban Development Authority is working on it.
Website accessible to the public. RTGL website.
Chandrasekhar, RDPR can take care of the Zilla Panchayat, Gram Panchayat, Taluk Panchayat, which would come under the revenue department. But there are CMCs, TMCs, which come under the Urban Development Department.
We got to the municipalities.
That will have to come under the UDD. And if it may be under the Advocate General's website also, so that everything is at one place. All the government advocates, SCGPs.
What responding to your lordship, maybe deleted your lordship, no prayer as I get.
You first affidavit haki, I will delete one.
Next year, E refers to Anand. The next year, E refers to Anand.
Actually, Mr. Bhatta,
Please.
so that they in future instruct you properly.
What I am suggesting your lordship, will please issue the notice to the director to the corporations like that. ನಮ್ಗೆ take notes ಮಾಡಿದ್ರೆ ಮತ್ತೆ ನಾವು ಲೆಟರ್ ಕಳ್ಸೋದು ಅವರು ಅದಕ್ಕೆ ರೆಸ್ಪಾನ್ಸ್ ಮಾಡಲ್ಲ.
Notice ಕೊಟ್ರೆ 6 ತಿಂಗಳು ಏನು ಆಗಲ್ಲ.
ನಾವು ಲೆಟರ್ ಕಳ್ಸೋದು.
Notice to corporation ಕೊಟ್ರೆ it gets returned, no such addressee ಅಂತ. Refused ಅಂತ ಬರುತ್ತೆ.
ಕಾರ್ಪೊರೇಷನ್.
Corporation ಬಂದಿದೆ ನೋಡಿ. Or, I think in one of the matters he has noticed it. What to do with them?
One thing is good, Your Lordship, because keep them from better vigilant on this part.
Assistance once they give us. Otherwise, without assistance, if we pass orders,
Yes.
it may be a problem.
Serial number 8.
Mr. Bhatt? Want to speak? Already, Mr. Chandrasekhar. Mr. Naveen. Look at the list now. Chairman, Mysore Urban Development Authority, Mysore. Served, no appearance. The Commissioner, Mysore Urban Development Authority, Mysore, served, no appearance. Special Tahsildar, Mysore Urban Development Authority, Mysore, served, no appearance.
They don't appear because they have delayed a fraud, they have delayed a fraud. By allotting the site in favor of the respondent number 3 on the grounds that they are the land user. Land was acquired in the year 1974. And there was a finding in this bill too, that there is no such site number at all. In spite of it, the commissioner has allotted the site. And he is disturbing my possession. Adjacent to that site.
This is one more reason why they don't appear. Shri T.P. Vivekananda is directed to accept notice for respond number 1, 2, and 3. Counsel for the petitioner is directed to furnish 2 sets of the petition along with annexures on said counsel. 6 and 12 arrow.
There are 6 so far as 6 concerned.
Private.
Each element, but 7, 8, 9, they're all.
6 and 12 aste, 7 ಎಲ್ಲ ಆಯ್ತು. Only 6 and 12 have to be served.
7 ಜೊತೆಯಲ್ಲಿ ಇದ್ದಾರೆ, age about 81 years. They are all residing in the same address, the last time in similar, residing at 3023. They are all
ಏನಂತ ಬಂದಿದೆಯಲ್ಲ 6.
ಒಂದೇ address ಅಲ್ಲಿ ಇರೋದು. ಇದೆಲ್ಲ ಒಂದೇ ಮನೆಯಲ್ಲಿ ಇರೋದು.
Someone say told. An affidavit to be filed by respond number 1, 2, and 3. Why there has been no appearance despite service of notice. Counsel for the petitioner submit that he will be making payment of necessary process fee in respect to unserved respond number 6 and 12 by 9th, Monday.
There are no application for rejection of this reason. Now, respond number 13 or 3 got this hearing by respond number 6 to 11, and they are interfering in the possession of the site in question. They are developing the land by virtue of the allotment made in favor of respond number 6 and 12, and in pursuance of the same hearing was inflicted by them. Now, actually, that site itself is not in existence. That is the endorsement given by the MUDA, and in spite of that, and in spite of allotting the alternative site, on the ground that there was no site.
Process fee is paid. Issue notice to respond number 6 and 12 returnable by 21st November. Respond number 13 is restrained from carrying out any development activities. You are appearing for respond?
Number 13.
Yes.
I didn't
Relist on.
JCB now, they came with JCB and started.
Current counsel for respond number 13 seeks for and is granted 3 days time to file her objections. Relist on 11th October. 11, 12, 10th and all times are 12, 13, 12, 13. 11, 25th, 13.
My lord, bring to respondent number 190, my lord. Report is ready, my lord. Please kindly pass over the matter, my lord.
Pass over. Furnish a copy to Mr. Reddy.
Serial number 10, Sachin DS, connected by
R1. That counsel for the petitioner seeks for and is granted 2 weeks time to file necessary application to bring the legal representative received respond number 1 on record. Relist on 2nd November. Interim order earlier granted with extension.
Litigation. I'm looking for litigation. Permissible delay.
for additional 2 weeks time in this matter. They have already started in short, so I am just working out whether within permissible limits. I want to.
From 8th August, you've been doing it, Mr. Kiran.
It's a 3-story building, no less 2 stories.
They will do it for you very soon.
Sure, they will come and demolish the structure, pillars itself. I
You
want
can
to
even
just-
option put it.
I want to ensure that the structure should not be get damaged.
But you can't be taking this much time.
No, I am aware of that. I want to improve this time.
That counsel for the petitioner seeks for and is granted 2 weeks time finally to remove the deviations. If the deviations are not removed by 27th October, direction would have to be issued to respond number 1 to 4 to remove the deviations. Released on 31st October. Whatever you want to do that.
But I will do it.
Serial number 12. Submitted by
On the last occasion, there was a direction was to complete this Friday.
Yes.
Now, this order ultimately came to be passed at the behest of the BDA.
Yes.
Now, BDA, can you see the first order passed by my lord? First order, which is on 1/8/2023.
Yes.
Insofar as BDA is concerned, it is at serial number 8. What is the duty of BDA? Item number 8. The BDA is also directed to place on record as to whether there are any sites have been formed in survey number 35% and ownership there. Instead of giving a report on this aspect, other than this, all the aspects there is a report. Now, under the guise of they say they want further information from the society, they say impeach the society. While this issue is whether they admit that in so far as 35% there is an approved level plan in their report. All they have to do is, as directed by my lord, go there and see whether sites are formed or not, and who according to their records are the Kaka issue. That's all. Instead of doing that, the report is submitted. Then bring
Have
the
you-
society also to the report.
Have you sanctioned the plan for that 7 number?
ಅಷ್ಟೊಂದ್ಸಲ ಮಾಡಿದ್ರು ಆಮೇಲೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆರ್ಡರ್ ರಿಮಾಡಿಫೈ ಮಾಡಿ ಹೇಳಿದಾಗ ನಾವು ಅವರಿಗೆ ಯಾವ್ದು ಡಿಲೀಟ್ ಆಗಿದೆ ಏನು ರಿಪ್ಲೈ
ಅದು ಯಾವುದು ಡಿಲೀಟ್ ಆಗಿದೆ ಅಂತ ನನಗೂ ಅರ್ಥ ಆಗಿಲ್ಲ, ಸೊಸೈಟಿ ಗೊತ್ತಿಲ್ಲ. Even as per their say, they have returned to the government.
So, Suman, the Supreme Court had directed them to surrender the land because the acquisition was not proper. It had to go
Yes.
to the landowners. Now, that also relates to 35/7.
No, it doesn't. In fact, I have produced that order of the Supreme Court
Yes.
in the writ petition, which my
Page
lords
number?
get, which my lords get at the page 127, 121, starts from 121.
Yes.
When you come to page 121, my lord, that is the last order of the Honorable Supreme Court, which holds the field as on today.
Yes.
Now, my lord, the relevant paragraph which my lords would see is at page 127. Kindly come to 127. The list is squarely covered ultimately, parallel 11 they read below. After hearing the senior counsel for the parties to the list, finally it appears to us that there is a serious dispute with regard to the extent of lands, which is the subject matter of these appeals. Therefore, we intend to clarify that this court, in the case of B. Anjanappa Supra, has confined the lands to 52 acres subject to Supli. This fact is also endorsed by the state government in its proceedings dated July 2012. The annexure to the government order clearly identifies the survey number and corresponding extent of lands which are the subject matter of these appeals. Only these were ordered to be restored.
When is this annexure?
Now, kindly come to page 130.
130.
130. This is the annexure to the government order.
You are survey number
35/7. 35/7 is conspicuously absent because it is not questioned. When these materials are available with the PDA, what is the question of they saying that they are asking for further materials?
(35/1), 35/4.
35/7. 52 acres surrounding Gunas total.
Mr. Vasan, 35/7 is not there. Page 130.
Either by not the media, it sees my petition and gives an absurd report.
They'll have to only surrender those lands.
Yes, and for which a compliance report is filed, in fact, incidentally, the society, what it did was, it's the developer who developed the layout, purchases many of these lands and integrates it with the layout. And last but not the least, the government, my lord was pleased to inform us as per the order. Calling upon the government to file a report.
Before parting to the record, the statement.
That paragraph 7 of my lord's order.
Where is the decision in B. Aninapa's matter?
So, previous first decision, in fact, that is the ultimate portion of that order, previous Aninapa's case is turned out in this very order. I should take the lordship to what
Where is the entire judgment?
entire judgment, is that is the previous page. That is at
Previous
page
page is
97.
extract, Mr.
No, 97 full judgment is it.
97.
Page 97. The first order. The operated portion starts at page 150. May I just state a few facts which led to the filing of this?
We come to page 115.
Please. Last
What
part.
the Honorable Apex Court has said is that the notification under 6(1) is not proper and 6(1) is gone. By the time the declaration of 6(1) should have been issued, the second para on page 115, the unnumbered
We
para.
may mention that.
We may also mention that
Yes,
there
we
is
can also mention direction given to the learned signature of 9,000 was infringed. Because the time limitation declaration of the section 6(1) could have been expired as expired. Yes, so this second. May I just state a few facts so that there is absolute clarity to the picture. Lord, two acquisition proceedings were initiated parallelly by the government in favor of the society. One pertains to Bangalore South.
On what basis are you making the submission as a purchaser? You are not the society.
I know the facts in the case, not because I am a purchaser from the society.
So you,
I know the entire fact, and all these facts are prepared even in the orders of this honorable.
from
court.
the reading of this order, what we understand is 6-1 could not have been issued. And everything was
Yes,
squashed and the
6-1.
land was directed to be returned by the society.
Yes, this one is for a 50 acre 17 foot.
No, that is where we are, that is the interpretation given by in the other matter. Now, if you look at this, if respondent number 1 is possession of the acquired land or any portion thereof, then the same shall be returned.
Yes.
That is only as regard the possession of 52 acres.
52 acres.
But
Now,
insofar as the entire 6-1 notification is concerned,
Lord, may I just take the option to.
please read the last para in 115.
Yes, I shall just clarify that by reference to the last part. If my laws were to kindly come to the.
First
second
read the
judgment-
last para, Mr. Soma.
Yes, yes.
The direction shall apply not only for the applicants, but other landowners who may not have filed writ appeals or especially petition may be due to poverty, literacy or ignorance.
Yes.
So basically, once 6-1 is gone, entire land which had been notified is gone.
No, 6-1 is not been issued. Insofar as 52 acres something acres.
Only as regard return of the possession
Yeah.
was the 52 acres.
I'm sorry, but I should just explain. That's why I said, Lord, this order itself is explicit. This observation that 6-1 is not issued is vis-a-vis those 52 acres 17 acres, which was notified for the second time.
Now, where is the 4-1, where is the 6-1 notification in respect of 35/7?
That is the first notification which my lords would get at in page 52.
52.
I'm
52 is not the notification.
sorry. 58, I'm sorry.
That is 4-1.
4-1. 4-1, your lordships would see at page 16, relevant is the
Axial number 31.
31. Now,
Yes.
time come to 6-1.
Where is 6-1?
6-1 is the
Page number?
is the next one in Kannada, which my lords would get at page 71, annexure L.
71.
Annexure L. The relevant is at page 75.
71. 71 is under 6.
Is 21/12/1986.
Yes.
Kindly come to page 75. Item number 31. B. Chaurappa, Nanjappa, 35/7.
What is acquired was 35 guntas.
Please.
Now this 6-1 was challenged.
No, this 6-1 to a 35/1 was not challenged. What was challenged was by various other landlords by taking a cue from the observation made in HMD Syed Kadar's case and connected cases in which the society is also a party.
That was in Anjana Pass.
And yet, no, that was not in Anjanapa's case, it was in the other cases earlier filed, where totally, by various orders passed by dishonorable court, 52 acres, 17 quotas were quashed. From out of this final notification, 52 acres, 17 quotas were quashed. The government, the society therefore moved to a fresh scheme saying we require this many 52 acres, 17 quotas which is quashed for in contiguity of lands, which was issued. Therefore, the government issued a fresh permanent notification.
Where is that notification?
So that notification I have not produced. I shall produce that tomorrow. But in civil opinion, what my lord was pleased to refer, it refers to that second permanent notification. Page 115, what my lords would see. It refers to the second preliminary notification. In fact, if my laws come to permit me to read page 119 onwards, page 121 onwards, entire facts which I want to narrate for my law's consideration, on which the society could probably submit is available for my law's consideration. May I read this order? Page 121. All the facts are here. May I read? These appeals, this is the second order in Bianjara case. These appeals are directed against the judgment or order of the division bench of the High Court of Karnataka and Bangalore in written appeal number so and so and collected matter dated 6/10 by these include order the division bench of the High Court has confirmed the judgment and order passed by learned single judge in WP number so and so dated 9/3/2004. The acquiring authority, well, this is the facts, who had acquired an extent of 165 acres 30 meters of land situated at Nagwara for the benefit of the society named Viral Society. Some of the landowners who had an interest in about 52 acres 17 meters of land had approached the High Court in India questioning the notification issued by the state government in section 4 and 6 of the Act. The learned single judge has allowed the aforesaid petition and passed the notification issued by the state government for acquiring the land to the extent of 52 acres 17 meters. It is apropos to mention here that the learned single judge has not quashed the entire notification. So I am only emphasizing this.
No, this is which notification? This is the first preliminary notification or second?
From one of the first two, preliminary and final, 52 acres were reacquired. Under that is coming forthcoming further. If my Lord might permit me to read further, it is forthcoming in this very order. But only part of the notification wherein the landowners have questioned acquisition of land to the extent of 15 acres 7 meters. The order so passed was confirmed. The society, this is it. The society has approached the state government in trade, containing that in order to complete the project, they have required the lands that were notified earlier and passed later by the High Court, and according to the request of the state government issued fresh notification under 4 and 6 of the Act to acquire the aforesaid extent of land so as to facilitate completion of project. Pursuant to said request, the state government has issued fresh notification. This is the second one.
In 1999.
Please, 28/7/1999. For the reason questioned, the state government thought it fit to withdraw the aforesaid notification by order dated 4/6/2001, aggrieved by the action of the state government. The society has approached the learned single judge in WP number so and so. The learned single judge has allowed the writ petition and directed state government to proceed with the acquisition of lands containing 52 acres 17 meters and complete the acquisition by issuing notification under section 6 of the Act and other requirements of the Act. Aggrieved by the direction so issued by the learned single judge, the landowners have approached the division bench of the High Court. Division bench has dismissed the appeal and thereby confirmed. Being aggrieved by the judgment so passed by the division bench, the landowners were in a civil appeal number so and so and connected matter. By order dated 7 to which my Lord was pleased to refer, 7/2/2000, reported by as Anjanappa and others by this court by disposing the appeal has issued the following directions. In the result, the appeals are allowed. The impugned judgment is also order passed by learned single judge and writ petition filed and dismissed. If the respondent is possession of the acquired land or any portion thereof, then the same shall be returned to the landowners concerned within a period of 2 weeks from today. This direction shall apply not only to the appellants but also other landowners who may have filed with the appeals or special petitions. May be due to recurrence power to However, made clear that the opposite direction shall not apply to such other persons who have withdrawn the SLPs. If any of these owners have received compensation, then the land shall be free to recover. Respondent number 1 is directed to submit a report to the complaints within 3 months from the date showing the complaint.
So this is the earlier judgment.
Please.
Now, in the earlier judgment shall apply to every landowner, whether they are challenged or not.
No, that was a confusion, as my Lord is this one, because the word uses acquired land.
Acquired land.
That is clarified in this judgment. It is
So
not.
now this acquired land, if we go by that order, it cannot be restricted to 52 acres, 17 meters. 1, 2, when there is a specific mention that it will not apply to those who have withdrawn the special leave petition. The annexure that you have pointed out refers to SLP withdrawn. There are 1, 2, 3, 4.
Yes.
4 items where the SLP has been withdrawn.
Yeah, so they have the benefit of restoration of possession.
So this is an interpretation which we'll have to hear the society. We can't go by your submission on that. Let the society come on record.
Then not
And we'll have to also call for all the documents from the state. As to
Lordship may have it up.
the state would have to file. Because there's a slight confusion here, which needs clarification. Because if it is, the entire acquisition is quashed for the, irrespective of whether it's been filed or not, because there's a procedural irregularity, the benefit of that was extended by the Honorable Supreme Court to all the landowners. So if the entire acquisition has been quashed, how this 52 interpretation is being sought to, we'll have to look at.
The entire acquisition is not quashed. That is exactly what the second clarification is. We hereby clarify.
But
Page 127.
once it is quashed, Mr.
No, kindly see para 11. That is where the lordship again, the same, because of the usage of the word acquired land, the confusion arose. Kindly come to page 127. Para 11.
You
After
you have
hearing
to
the
come
Lord's
to 115 is where it was quashed.
Please kindly come to page 127,
Yes.
where the worships clarify what was the effect and purport of the import of the earlier order. After hearing the senior counsel, it appears that there is serious dispute with regard to the extent of lands which is subject matter of these appeals.
No, that
Therefore,
was-
we intend to clarify.
You may be right until we get those details of what was challenged, maybe 52 acres, 17 muttas. That clarification, there cannot be any problem with that it was seized of 52 acres, 17 muttas. But in the earlier judgment, the direction shall apply not only for the appellant, but other landowners.
No, that
That
is
is
why
why the
complaints report was filed. Complaints report is accepted by this very judgment. Complaints report is also accepted.
Yes, sir, let them also come on record. You file your detailed statement, madam. What is?
Report saying that, whatever the return to the original owner transfer the direct.
Everything.
Report is everything.
No, the Tahsildar, though my lord was pleased to direct the government, ironically, this report is submitted based on the letter of the Tahsildar. You can also see. And what is conveniently suppressed by the Tahsildar is that he says we have issued Subhudu Patras to restore possession. What is conveniently
When
suppressed
was
is
the report submitted?
only a memo, my lord. Not a report, only a memo.
You have to file a report, madam. These are only enclosing the documents is not
The
sufficient.
statement of objections at page 144, the report.
Other whatever my lord said is the Tahsildar.
You are not the state. The state has to file the report.
The
That's a
state
state file.
has earlier submitted before the Amal Apex Court and before this Amal Court, those documents are present.
See, unfortunately, here you are the landowner. You
Landowner.
are a site owner. The society is not here and the state is also not saying anything. These are the two main players and BDA, third player.
We are only the plans.
Both of you are saying what you want to say, but they are the important people here. Yes, Mr. Krishna?
No, we are concerned whether on the plan sites and earlier I filed the statement stating that well, at the first instance when the plan was sanctioned, the survey number was included. Thereafter, we have the decision of the Supreme Court. We have called upon the society as well as the government, stating which of the lands are deleted from the equation as per the order of government. Till then, we have not received any communication from them. Therefore, we have also called upon the society.
So what has happened to the plan?
Plan is finally as on today as it is. We have called upon, once we have cancelled.
You are cancelled.
And that was satisfied by the.
The reconsider, it was limited to reconsider the matter. Thereafter, we issued a notice to the society as well as the government, seeking the details from the government, which of the lands are deleted. And we also called upon the society to furnish the details, which of the lands are deleted, and furnish the modified layout plan to approve. That still we have not received any response from the both sides.
Because it has to be in terms of the scheme.
Yes, sir.
So the scheme would have to be amended by the state.
Yes, sir.
So that scheme has not been amended by the state.
After that, only we can modify the layout plan. Deleting the area which was deleted.
File a report, madam, of a responsible officer as to what has happened. So 35/7, you had issued a plan sanction earlier.
Yes, yes.
Now we'll have to ascertain only whether that has been,
It is,
whether the interpretation now given by Mr. Suman tallies with all that records which have been filed. So the compliance report also you'll have to place on
So
that.
let them comply with my law for things letters first. My law always.
He's making a submission
Over serious sites are on in 35/7. Why is it that they're fighting side?
To go there and see is not the issue, Mr. Suman.
No, my law is also I'm only saying.
Our order is whether it has been, the sites have been formed
Yes,
and ownership relating thereto.
that's an issue implicit.
Yes.
That has not
Yes, you
been
are.
answered.
You comply with para 8 and the state also would have to comply.
The layout was formed by the society. We are only approved the layout plan. Society is.
I think a society barbeco, file an application.
Procedure does it. The only problem is I will play on both sides. Honestly speaking. Because I am also incidentally the man who went up to Supreme Court and argued this matter.
And there's a conflict.
Yes, there will be a conflict personally.
Then that is for you to decide. We can't tell you anything. There's a conflict between the petitioner and the society.
There is no conflict. So there is no conflict between the petitioner and the society. If the unity, if society becomes a former respondent, I will find it difficult to represent both sides.
When will you file your report, but
Then punish complete set.
complete set, avurenu kodಬೇಕು. The petition they can give, but the records are with you.
Because they're not complete, punish the complete set, annexes are not.
You furnish a full set of the petition.
I shall publish for the first time.
I have to go to India on that.
Your entire proceedings in your office would be on those orders. So what have you done on that basis is what, anyway, give them a copy.
2011.
Learned AGA submit that the set of papers which have been furnished to the learned AGA is not complete. In that view of the matter, learned counsel for the petitioner undertakes to furnish 2 sets of complete documents by end of 10th October. Learned AGA seeks for and is granted 4 weeks time to file a detailed report of a responsible officer indicating the actions taken pursuant to the judgments of the Honorable Apex Court.
As referred in the legislation.
As referred, in next judgment is gottilla na. So if there is some other judgment, they'll have to say whatever they've done. As also to place on record the original files relating thereto. Relist on 16th November. Earlier granted is extended till next year. 4 weeks, 4 working weeks anta idira. Released on 22nd November.
Okay.
Yes. What is this amendment? And,
The direction which that one is important side to remove that drainage, whatever they have done, that they have exit, whatever, is on the petitioner side.
yes. And you want to implead whom now?
The chief engineer Karnataka urban water supply and that has to reach board the particular director.
IA 3 of 23 has been filed to implead the chief engineer Karnataka Urban Water Supply and Sewerage Board, Shri Suhas, HS Suhas. He is directed to accept notice. Oh, full Karnataka ge avaralla. Karnataka Urban Water. Shri HS Suhas is directed to accept notice for the proposed respondent. Counsel for the petitioner serve copy of the entire petitioner along with the application on the said counsel. IA 2 of 23 has been filed to seeking for certain amendments to the writ petition to place certain additional facts, grounds, and an additional prayer on the said facts. Being of the customary opinion that the facts which have been stated are necessary for properly and effectively adjudicating the dispute between the parties. More so when there is a further relief claim for removal of a drainage which has been put up. IA 2 of 23 is allowed counsel for the petitioner to carry out necessary amendment and file amended petition. Relist on 15th November.
That's it.
ಎಲ್ಲ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿ ಇವಾಗ ಅಮೆಂಡ್ಮೆಂಟ್ ಅಲೋ ಮಾಡಿದ್ದನ್ನು ಮಾಡಿ ಸುಹಾಸ್ ಅವ್ರಿಗೂ ಕೊಡಿ, ಸೋಮ್ಯಾಜಿ ಅವ್ರಿಗೂ ಕೊಡಿ. ಎಸ್ ಅರ್ಜೆನ್ಸಿ ಏನು?
I have filed an application.
You have an interim. That on behalf of the counsel for the petitioner, a short adjournment is sought for on the ground that there is bereavement in the family. Released on 31st October.
Take a short accomplishment.
Short accommodation andre? When do you want?
1 week.
Next week you want?
Please.
The request of counsel for respond number 2 released on 25th. Supposed to agree? Four and five. Four is Settielli Gram Panchayat. PDO Settielli Gathiram. Narayan Reddy. So Narayan Reddy will appear for 4 and 5 also. The M. Narayan Reddy has entered appearance for respond number 1, 2, 3. And as such, Shri B.J. Somyagi submits that he would also be appearing for respond number 4 and 5. Registry is direct print the name of Shri M. Narayan Reddy as that appearing for respond number 1 to 5 and delete the name of Shri B.J. Somyagi as that appearing for respond number 4 and 5. None appears for respond number. There is no appearance on part of Mr. Narayan Reddy today. Relist on 35.
I a paper respondent millet. Sorry, millet.
You all could here vehicle of Narayan Reddy.
Sorry,
Ready?
millet. Some mistake. I'm not at file the statement of objections, millet. I will get the instructions.
Narayan Reddy seeks for and is granted. When will you file?
After vacation, millet. After vacation.
Seeks for and is granted 3 weeks time finally to file a statement of objection. Objection statement will be filed on or before 3rd November. Failing it will be taken as not filed. Relist on 9th November.
Obliged.
I am representing the India President. I am also paying for objection.
Respond number 6 also seeks for and is granted 3 weeks time finally to file a statement of objection. If not, that's all. Interim order earlier granted is extended next time.
Today morning, I received the copy of 17 to 22, 25, 31.
1 nimisha. 17 to 22. Shri A.V. Gangadharappa accepts notice for, then an AG accepts notice for respond number 1. Shri A.V. Gangadharappa
17 to 22, state is not the party.
not a party. Shri A.V. Gangadharappa accepts notice for respondent in view of so and so. Amele?
25, ಅದರಲ್ಲಿ ಸ್ಟೇಟ್ ಇದೆ 31 and 32 ನಲ್ಲಿ ಸ್ಟೇಟ್ ಇಲ್ಲ.
Whereas AGA accepts notice for respond number 1, AV Gangagrappa for respond number 2.
In 31 and 32, my lord, there is state is not a part.
31,
32
32. AV Gangagrappa accepts notice for respond.
and 40, my lord.
State party idea.
So,
40, AGA accept notice for respond number 1, AV Gangagrappa for respond number 2. Amendment ಆಗ್ಬೇಕು Mr. Raj. So it's entered in CIS. After entry, we can't make any change.
could be allowed. Only this.
Amendment ಆಗಿದ್ರೆ ತಾನೇ allow ಮಾಡಿ.
Spelling mistake in the initial.
Amendment application will have to allow it. 40, AV Gangagrappa accept notice, released on 11th. 11, 12, ಯಾವತ್ತು? Application ಯಾವಾಗ? Released on 10th. File ಮಾಡಿ, amended petition ತಗೊಂಡ್ ಬನ್ನಿ. 40, 12, 10.
Serial number 23.
Process was identified. Fraction, the last pregnancy, annexure C,
Next is, yes.
our panchayat has identified the.
ಮೂರ್ 3,375 ಮನೆಗಳನ್ನು ಮಂಜೂರು ಮಾಡಿ.
ಎಲ್ಲ ಐಡೆಂಟಿಫೈ ಮಾಡಿದ್ದಾರೆ. Panchayat wise the people are identified, the persons identified. Thereafter they were lost to pregnancy after the change of government. Without any reason, annexure A is passed, that are sanction and allotted to Purigalta.
Allotting it to Pungal.
Purigalta, without the sanction, it was granted in favor of Turvekere.
So the scheme has been shifted from
Shifted
Turvekere
to Turvekere to Purigal, without any reason. And already the persons are identified, Taluk is and Gram Panchayat wise are identified. All proceedings were held. And
and AGA accepts notice for respond number 1 and 2. Turvekere yaru? A. Nagarajappa, ZP Tumkur, A. Nagarajappa for 3 and 4. The operation of the order dated 7/7/2023 at annexure A issued by second respondent is stayed till the next date of hearing. Counsel for the petitioner served 2 sets of the petition along with annexures on the opposite counsel. Objections, if any, to be filed on or before 10th November, released on 17th November. Upload ಆಗುತ್ತೆ. ಅವೆಲ್ಲ ಇವಾಗ ಬಿಟ್ಬಿಡಿ, ಡೆಲಿವರಿ ಎಲ್ಲ ಅಪ್ಲೋಡ್ ಆಗತ್ತೆ. ಈ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ನಿಮ್ ಕೊಲೀಗ್ ಮಾಡ್ತಾರ ಅವೆಲ್ಲ.
Petition
2019 man.
2019 matter, petition was held on 29/5/2019. And the repeat files was filed on 3/7/2019. That's a 5-year term. 13 months are left there. That's it's been adjourned.
And AGA accepts notice for respond number 2, notice to respond number 1 is dispensed with in view of the proposed order to be passed. Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that the election petition, which has been filed in the year 2019, is still pending after nearly 4 years. And as such, the interest of the petitioner would be affected in terms of his election prospects in future elections. Ian, what is the stage now?
Orders on IE, they filed an IE.
Is the evidence done?
It's at the stage of evidence.
As the petitioner led evidence?
Yes.
Cross-examination is over?
No, it started. After that, they filed an IE.
You have to cross-examine.
They have to process.
When will you cross?
They will file an IA after IA, that's one of the jurisdiction, one on maintainability, and they continue. Now they filed an IA number 9 on some issue whether seeking for production of additional documents. So it's that whether is going for orders for last 9 hearings, whether it's been turned to page number 64. The type copy is there.
Which court is this? Unigal.
Senior civil judge in jail. Page 22.
This is posted for respondent evidence. At that time, they filed the application.
Yes.
The approval of the order sheet indicates that when the matter is posted for respondent evidence,
21.
an application under Order 7 Rule 11D was filed on 13/4/22. Thereafter, the matter came to be adjourned on several occasions. And even after the arguments were concluded from both the sides on 27/9/2022, the matter has been adjourned. This is 10/1. After 10/1, what happened? For nearly a year at that stage.
I was told that the order sheet is not complete, but it's continuing.
Orders.
Orders. Oh,
And continue posted for orders for nearly a year as per the submission of the learned counsel for the petitioner. That it goes. If that be so, the gross delay which is being caused whenever an application is heard, orders would have to be passed within 15 days, whereof which has not been done. The period of the order sheet also indicates the matter being needlessly adjourned from time to time. In that view of the matter, I pass the following order. Petition is allowed, a mandamus is issued directing the senior civil judge at Kunigal to expeditiously dispose of the election petition number 2 of 2019, preferably within a period of 6 months from the date of receipt of a copy of this order. The submission of the learned counsel for the petitioner that the petitioner shall cooperate with such expeditious disposal will not take any unnecessary adjournment is placed on record.
Finish copy.
Copy. Venkatachalapati. Two 48(3). The Pawan Kumar accepts notice for respond number 1 to 4. Issue emergent notice to respond number 5 returnable by 3rd November. In the meanwhile, this council for respond number 1 to 4 place on record the steps taken by the corporation post the order passed under subsection 3 of section 248 of the BBMP Act. Released on 8th October and November.
Serial number 27.
Advishaya,
In this matter, I represent petitioner, my lords.
yes. Eli.
Petitioner is the petitioner is the grantee of the site, my lords, as per annexure A.
There are no interim orders sought.
Yes, my lords, I have not started.
And AGA is directed to accept notice for respond number 1. Taluk Panchayat Shumaka. BK Somyaji accepts notice for 2 and 3, issue notice to respond number 4, returnable by 20th November.
Much obliged.
28.
Mr. Kumbar. BG is directed to accept notice for respond number 1. Mangalore Urban Development Authority. Harish Bhandari is directed to accept notice for respond number 2 and 3, cancel for the petitioner serve 2 sets of the petition along the connection with said council objections if any by 10 dated on 20th November.
29. Yes,
Mr. Venkateshwaran. Venkateshwaran. Vasu.
Serial number 7.
Who is carrying the construction? Respond number?
Respondent number 3.
3 is there.
Respondent number 2. LDC election, 3 farmers members are.
Conservancy is a public property vested with you. Nobody can have access. Pawan Kumar accepts notice to respond number 1 and 2. Issue notice to respond number 3 returnable by 16 November. Second respondent is directed to cause a inspection of the Conservancy Lane. Starting from Stephens Road, ending at Kenchappa Road, Fraser Town, bracket Pulkeshi Nagar, Ward number 78, to ascertain if there is any construction being carried on in the said Conservancy Lane, and if such construction is being carried on, to stop the construction as also to remove any unauthorized construction. The inspection to be carried out commencing from 10:30 a.m. on 25th October 2023. Report to be submitted by 31st October, released on 6th November. Process fee and copies to be furnished by end of day 9th October, telling me the interim order will stand automatically. Cantonment Act on reference is welcome. Conservancy was for the purpose of, because the Conservancy Lane was implemented when the cantonment was established in Bangalore. Other lane on the night soil.
Conservancy lane, but they have adopted the not for street.
Because that vests with the state or the municipal authority, not a private property. So Sharon? Yes. What about your construction? The Pawan Kumar accepts notice for. You only made the town planning member a party. You have to make that. Pawan Kumar accepts notice for respond number 1, issue notice to respond number 2, written up by 21st November. Respond number 1, along with the jurisdictional estate executive engineer, is directed to cause inspection of the property of the petitioner bearing number 420 6th Cross 2nd Main, RBI layout, ward number 195, Bangalore 560078, as also the property of the respond number 2, bearing 419 6th Cross 2nd Main, RBI layout, Bangalore 78, to ascertain if any construction is put up so and so. The inspection to be carried out commencing from 10:30 a.m. on 25th October, report to be submitted by 31st, released on 6th November. In the event of the construction being carried out without any plan sanction or contrary to the plan sanction, the respond number 1 and the assistant executive engineer shall ensure that there is no further construction carried out. Process fee and copies to be furnished by end of day 9th October, failing which the interim order will stand automatically vacated.
24, Umapati is
They have, there's no plan sanction for the construction.
We have to ask for it, but they say that there's no plan sanction. They say that subsequently they put the cost.
What about,
Even the building of the height, height is about more than 13 meters. They say it's only 13 meters.
who is the petitioner?
But petitioner is person who's local resident.
Local resident won't come before this. If he's a neighbor, yes. So it will go as PI.
Then it has to be permit to convert it to PA. Otherwise, you don't understand direct issue notice.
We cannot.
Whatever, we are also not, I don't want.
If you are neighbor or residing opposite also is fine. But otherwise,
Or if your versus not calling properly needs to be another neighbor. ಬಂದಿದ್ರು ಆಮೇಲೆ ಅದೇನಾಗುತ್ತೆ ಅವ್ರ ಪಕ್ಕದಲ್ಲ
ಅವ್ರು ಬರೆದ್ರೆ ಅವ್ರಿಗೂ because every neighbor we are directing their inspection also. It's all. Will what do you want?
ಅಲ್ಲಿ ಭಯ ಆಯ್ತು ಅವ್ರಿಗೆ ಇನ್ನೇನಿಲ್ಲ ಫಸ್ಟ್ ಕ್ವೆಶ್ಚನ್ ಐ ಆಸ್ಕ್ಡ್ is where the property in accordance with the plan. They said yes, showed this plan also.
The perusal of the petition indicates that the petition has been filed in public interest, alleging that respond number 5 has carried out construction without a plan sanction. That being the case, registry is directed to place the matter before the Honorable Chief Justice for necessary orders. In the meanwhile, counsel for the petitioner to comply with the requirements of public interest so rules.
35, Henry Sundaraman.
Yes. How is your construction? Anyway, we'll direct your this one also. And Shri Pawan Kumar accepts notice for respond number 1 and 2, issue notice for respond number 3, returnable by 21st November. How is your construction, Mr. Arun? How is your construction? We'll cause an inspection, and if it is in violation, we will take action.
But in meanwhile, they did not construct, because sitting on our wall, who take it to that?
This is what we'll ask them for inspection. If it is contrary to the plan sanction, they'll ensure that no further construction, but they'll also inspect your property. Respond number? Yes.
Violation of sanction. But the other ground that you're raising. The other ground that.
Take 10 breaths and then.
Other conditions that you're raising. Well, apart from all of these, they fill soil within that level and make it in such a dangerous height that the wall will crash. That is the report. Thank you for the report that you.
Page.
Now, again, you can see the report that is at simply studying that picture next.
Page.
Page 43 is the report.
Yes.
Maybe now this is. Now, can I just point out to one sketch before the report?
Hmm.
Then you get page 38.
Yes.
Well, this is the sketch, is part of the report that is produced separately here. Now, can you see on the left side, is first is our stone masonry wall, which is the bottom wall.
Hmm.
Above that wall is our compound wall, which is brick, which is hollow block masonry.
Yeah.
Now, can you see what they have done? They have filled soil on the other side, right up to this level, and put their wall not on that, into that thing. So, this is the study that is.
They've put up a wall on your wall or a separate wall?
No, they filled soil on their side.
Yes.
And within their side, it's not exactly on my wall, but it's just a vertical, not wall.
So there's a separate compound wall built by them.
Yes. They have built the wall into that. Now,
Yes.
what's happening is the entire weight of this is on this, because of which the walls have developed cracks. And that is the stability report in the next one. That's a big point.
But we cannot direct it to be removed now.
So, let them inspect. The
Inspection.
wall major is also.
That is what we will direct. It looks like they've built it on your wall.
It's almost like that, but there's a small gap between. Maybe about an inch or two.
Yes. In page 77, there's a gap. The other photographs look as if it is.
Yeah. At page 77, we'll not see that a small gap. The bottom, left-hand side bottom.
If Pawan Kumar accept notice for respond number 1 and 2, issue notice to respond number 3, returnable by 20th November. The issue is only as regard the compound wall, not as regards any other construction.
No, the only reason I am agreed because the construction there. In addition to that, they are now putting up huge steel structure within that setback area. Everything will collapse onto our property.
Respond number 2 with the assistant executive engineer and or the assistant executive engineer is directed to cause inspection of the property of respond number 3 in what is the details of the property? Where is the property located? Address. Postal address. What is to be inspected? Which property has to be inspected? So the response registered address you are given. But where is the property of respondent? And your address also is as vague as it can be. There's no address at all. Having officer Ryan International School. Inspecting council needs to do a better job. Yes. What is the property to be inspected? Where is the property of respondent number 3, Mr. Arun?
Property of the respondent. And Article 2 square.
Page number?
By the structural engineer. There is so.
That also is not there.
Report for.
For is you. Please find out. The relief itself will not be maintained because the property is not described in the petition. So please file necessary applications. Ashu.
PS Kumar,
Mr. Kumar. Hmm? Yes. Hmm. So you had, your order was issued on 24/7/23.
Now we look at the entire anybody can. That all is passing.
We can't stay this order.
No, I want recently they have passed an order. There is no such order will pass in the respect of anybody. They can purchase from anybody. Can ask 28.
What is the relief that you are seeking
Then
for?
it is without that earlier it was brought into me.
Yes.
That order is cancelled. Again, that I have applied. Subsequently, 28/8/23, the corporation has issued an order. That there is an order that no such order has been passed. Anybody can supply. That's the order then.
So you can also supply. That was always available.
But because of they are-
Find out what it is. The Pawan Kumar accept notice for respond number 1 to 3. Counsel for the petitioner served 2 sets of petition along with annexures on the said counsel who seeks for and is granted 2 weeks time to obtain instruction, make his submission, released on 31st.
Ramesh Chandra,
And what happened is the operation and the and other. However, there is a approval. Construction is violation of the.
248, 1 and 2 ಆಗಿದೆಯಾ? 3 ನೂ ಆಗಿದೆಯಾ? 356 ಆಗಿದೆ.
Action ತಗೊಳ್ತಾರೆ. 356 IFI 28 ಆ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟು ಅಲ್ಲ ಮಾಡಿದ್ದಾರೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡಿ ಎಲ್ಲ ಮಾಡಿದ್ದಾರೆ ಏನಾಗಿದೆ ಅವರು ಇಂಜಿನ್ ನಡೆಸ್ತಾ ಇದ್ದಾರೆ 3 ಜನ ಕೂತ್ಕೊಳ್ತಾರೆ ಅದೆಲ್ಲ ಔಟ್ಸೈಡ್ ಅವರು ಬೆಂಗಳೂರು ಹೊರಗಡೆ ಇರೋರೆಲ್ಲ ಕಾರು ಎಲ್ಲ ನಮ್ಮ ಮನೆ ಮುಂದೆ
No plan sanction. Violation.
ಬರ್ತಾರೆ 24 ಬರ್ತಾರೆ ಅವ್ರು ಆರ್ಡರ್ ಬರ್ತಾರೆ ಟ್ರಾನ್ಸಾಕ್ಷನ್ 24 ಇದೆ.
The Pawan Kumar accepts notice for respond number 1 to 4, 1 to 5. Issue notice to respond number 6 to emergent notice to 6 to 10. Returnable by 10th November. Counsel for the corporation seeks for and is granted 2 weeks time to ascertain and make a submission on the action taken post the notice issued under section 356.
38. Prakash Ramesh,
Pacho,
29, 30 pages.
two 248(2). In a 248(3) Agila. The Pawan Kumar accepts notice for respond number 1 to 3 issued emergent notice to respond number 4 returnable by 10th November. Respond number 3 shall carry out an inspection of the property of the petitioner. Improperty details in site number 4. As respond number 4, Nimdo, petitioner. Same locality. Same locality, you can't file this. You have to file a PI. You're a neighbor, Andre, it's a private interest. Is the respondent your neighbor? And he is constructed on CSI. It's a public interest litigation. Not a private interest. You are not a interested, privately interested party, affected party. File a PI or we'll convert this into PI. A peril of the government's made indicates that the above matter that counsel for the petitioner, Shri Pawan Kumar accepts notice for respond number 1 to 3. That counsel for the petitioner, after arguing for some time, seeks permission to withdraw the above petition with the liberty to file a public interest litigation. Reserving such liberty, the petition stands dismissed.
41, Samithya's.
Yes. Oppose the matter before a bench of which SGRT is not a question. We can't fix it.
42,
Nimmer property also. Adjacent property. The Pawan Kumar accepts notice for respond number 1 to 4, issue emergent notice to respond number 5. Returnable by 10th November. Respond number 3 and 4 are directed to cause the inspection of the property of the petitioner. Nimmer property and detail. Nimmer property details here. Nimmer property details here clearly and clearly. What is your property details? Property number 7, Chandrodaya School Road, 2nd Cross, Gokula First Stage, 4th Phase, Matikere. As also the property of respond number 5. The property of the petitioner bearing number 977, 2nd Cross, 7th Main, KN Extension, Yeshwantpura, Chandrodaya School Road, Gokula First Stage, 4th Phase, Matikere, Bangalore 560022. As also the property of respond number 5, namely 978, so and so, to ascertain so and so. Inspection to be carried out on 25/10/2023, commencing from 10:30 a.m. Report to be submitted by 31st, relist on. 10th November. In the event of it being found that the construction by respondent number 5 is without plan sanction and or is contrary to and or is in violation of the plan sanction, respondent number 3 and 4 shall ensure that there is no further construction carried out. Process fee and copies to be furnished by end of day 9th October 2023, telling you the interim order will stand automatically. Will be uploaded.
Personal hearing, serial number 43.
Yes. Hmm. 7-9. Yes. You have placed it. You're right. Our compliance ಮಾಡಿದ್ದಾರೆ ಅಂತ ಅವ್ರು ಹೇಳ್ಬೇಕು.
ಇಲ್ಲಿ ತನಕ ಮಾಡಿದ್ದಾರೆ. ಈ ಬಿಲ್ಡಿಂಗ್ ಪ್ಲಾನ್ refers to June 12, 2014.
When did you file it, Mr. Shetty? Mr. Shetty? When did you file it? So you want us to see the report of 1510? Page number?
Page number 107 of my additional section 5.
You want us to see their report or
Their report only, before getting into it, why they are suppressing that particular document or the officers content were working there since 2004. Only they start from 2005. Like in efforts to pursue my point here in the direction, I will be present to page 107 on this particular additional document.
When did you file your additional documents?
That was the 4/7/2022.
Yes.
107.
Yes.
May I just need to watch it? The Shara written there.
Now you have taken us to the. You have taken us through both the dates. That is why we had asked them to give the date, details. 22/12/2004.
Very good. Now, the information furnished in reference to the officers per sir is only from 2005.
ನಮ್ ನೋಡಕ್ಕೆ ಬಿಡ್ತಾ ಇಲ್ಲ ನೀವು ನೋಡೋಣ ತೆಗಿಯೋಣ ಅಂದ್ರೆ ಇಲ್ಲಿಗೆ ಹೋಗ್ತಾ ಇದ್ದೀವಿ. ವಾಟ್ ಇಸ್ ಬೀನ್ ಗಿವನ್ ಅಂತಾನೆ ನೋಡ್ತಾ ಇದೀವಿ. Yes. Where is the list of officers who work? From 1/5/2006 you have given, Mr. ಅದಕ್ಕಿಂತ ಅವೈಲಬಿಲಿಟಿ ಇಲ್ವಾ? It is not difficult to secure it. We'll have to direct the AGA to secure it. But if you are not giving it, your officers are not giving it, and we have to secure it from there. You have made, but your officers have made. You find out, Mr. Chandrasekhar. There is the interpolation of a plan sanction done in the year 2004. One date is 2005, another date is 2004, which are per se contradictory to each other. The submission of the petitioner is it has been backdated only to secure the interest of the respondent, the private respondent. That's why we'd ask them to give the details of who is that person, because the name of the officer is not there.
So who is the concerned official at that time?
They were given us details from 1/5/2006. And not.
That is the core issue.
Saying as if they are provided but not providing. Yes.
Then another will be fine. Reason is, this is the one second, please, I will take an audience, please, sir. Non-subject matter.
Everybody.
That is on the board, is the director of the official to figure there. Assigning these measures, whatever. it is.
The responsible counsel is making a submission.
Here, my next submission is 2 weeks back was, I will set it, but there's you are. In that is, it is nothing but the voting contribution. I demonstrated in another way how this particular document is. Why it is, when it was fabricated. All these things has to be known as brought from the government. Reason is, that is the very core issue. I am contending that the British National Plan, the document is a fabricated document, preserve it like the. And when I demonstrated that, I have to just go back, anyway, I have to get back to the one and two are without license. I only requested. This report, suppose by chance, contemplating the situation, if I may have to prosecute the officer concerned, I should be knowledge as to who those officers are.
Yes.
So in that regard, an affidavit from the concerned officer who has now submitted the report, if they can file an affidavit here, let us proceed.
Yes, you are saying something.
Because of the involving government scan the gap the municipal. Accordingly, they have all that was. Till today, because the next page is.
Next page.
Page number 9.
Which page?
Page number 9 of the very same memo.
Your memo.
Please. The sheet provided that.
Now he is making a submission. Please wait.
Yeah. One by one, we did about 20 days. To comply the order of this foundation. Sincere effort we have made a lot of respect to your employees who has charge of the university and who has issued the license. Even the Lord my friend who has got the license, that document also we don't have. The license which the petitioner which he is having and constructed, that license also we don't have. But he is having a xerox. He also does not have original copy. I have a original. He has not given at the time of the survey when he went. We have given the original. Please.
You can reply, not interrupt.
So that my lord. From the date of the enactment of the municipal act,
we appreciate the work that you have done. You find out and give us because festival work you have done. In a period of 14 years, there have been 35 officers.
And all officers. Well, then my lord, we collected everything one by one we did, and the date, the top date also.
Some of them serving only for a month or 2 months.
basis, right?
Nobody will know what is happening. Every 2 months, people change. The Pawan Chand Shetty, then Council for Respond number 1 has filed a memo dated 27/9/2023 enclosing the list of officers from 1/5/2006 till date. The TMC chief officers of TMC KRP from so and so date till from 1/5/2006 till date. He submits that insofar as the relevant period of 2004 to 2006 are concerned, the details were not readily available, and that an effort would be made to secure those details and place it before this court. Yav Martira. Relist on.
One engineers.
I have, my lord, annexed in terms of the order.
Yes.
Yes, sir.
The following page, the order implemented.
Engineers list also 2005.
Yes.
Similar submission is made as regards the engineers prior to 1/4/2005.
And my lord, many of them, my lord, retired from the service, and their, my lord, address is also not traceable. It is in column number 5, my lord, we have stated. Nivrutti agidare, villasa patte illa.
What we need
And
to
my lord,
understand is if that is a fabricated document being relied upon and that officer is not signed it, then everything goes of respond number 4.
But ultimately, because of this, these two persons dispute, my lord, we are not able to discharge any public duty. He has stopped to give the license to anyone now. He has a double careful chief officer. He said, last week I came, sir. What can I do, sir? We are, and without conversion order, we don't want to issue single license to anyone. No, my lord, everybody is before no politician. The TMC officer is not given any license to anyone.
Without conversion, you can't give.
Yes, my lord. Earlier, what is happening, my lord? Revenue side, everybody was started to give because of the oral direction of the authorities, legislatures. Now, my lord, he has stopped. He said, I may remain, my lord, 2 weeks or 3 weeks. There is a chances for transfer again.
You follow the
Yes, sir.
applicable law.
Procedure. Please.
Otherwise, all these revenue sites,
Very.
you are putting them in trouble if you give them signs. So they'll invest their hard-earned money there for a shortcut.
No one taken conversion, my lord. He was my petition, respond number 2. No one has taken conversion. Ellaru kattide revenue ata idralli. Even today they are saying so many things. If they are converted, my lord, it is easy for me because the reference must be in the DC office.
Layout ಮಾಡಿದ್ರೆ layout conversion.
Conversion order.
Conversion ಇಲ್ಲ layout in there.
No, my lord. That
Please,
direction
sir.
was.
The counsel for the petitioner also seeks for a week's time to place on record the conversion order in regard to the lands of the petitioner. You list on.
Junior engineer.
ಎರಡು ಹೇಳಿ. So also is the submission and case.
I just want to, I take no comment. That's why I'm just reading and requesting. Asking me to please to direct the officer, file an affidavit. The reason is, tomorrow if I want to prosecute.
If he is going to give the details, why should he file an
No,
affidavit?
he is not going to, for the reason
Why
that.
are you presuming it, Mr. Counsel? This is not the way that you can make. You cannot make that submission until he does.
From the records, I can just make a decision. Yes, given reply to my RTI, stating that the concerned clerk has not given the charge once. Second
Mr.
application,
Keshavamurthy, when a counsel makes a submission, we will accept.
I leave. Now, my object
You
is.
don't make that kind of a submission against a counsel. He says he will find out and give it. He'll make his endeavors. They made a good work on this and given so much details. Please don't make those kind of things.
Yes.
We list, Yavattu, Mr. Shukla.
12th or 13th.
My lords,
On
I
our
have not come to this one. ಯಾಕಂತಂದ್ರೆ ಮೂರನೇ ಸರ್ತಿ ನಾನು 3 ಕೋಟಿ ಮುಂದೆ
We list on 27th for further hearing. 27th for further hearing.
Yes.
ಕೇಳಿಸ್ಕೊಂಡ್ರೆ ಇಲ್ಲ.
Serial number 44. The current person is connected by the
27th inconvenience ಇದೆಯಾ?
26th.
31st ಹಾಕೊಳ್ಳೋಣ. 31st. Mr. Basraj.
Okay. Measurements of the properties. On this case.
Yes.
Because of the argument, we have also taken up private survey. The survey that is the approved survey. The sketching of a prepared work, any one to sketch, the page of 5 minutes. Next,
Yes.
we put at the top. Last we find the Saint Thomas Community House belonging to the petitioners. It is constructed by petitioners. It is not in district. The plan is also sanctioned, which I have produced along with the rejoinder in the connected information.
This is a survey sketch. Where is the survey report? On what basis was this survey done and the markings made?
As they have done some survey and produced sketch plan, they also.
So both of you have done somewhere and both of it will ignore.
Both the surveys are considered equivalent. It is not a joint survey. It is not a joint.
Joint survey is different. What is the basis is different. How are these points marked? There must be some revenue survey.
It's on the title deed, that is annexure A. If the particular property is not strip A, strip 1 to 8.
1 to 8 strips illa ide.
Strip 1 mark sketch.
2 to 8.
2 to 8 of course. That is not in dispute. This is the area where they are claiming that to be corporation property.
So your strip 1 is 11 acre 3 gundas.
I have produced the dimensions. Page number 4.
Your survey report says 11 acres 3
Oh,
gundas.
that's correct.
4,847 square meters.
Just one, page number 4, dimensions are 4.
Yes.
4,99,790 square. It is in conformity with the measurement shown in annexure A. The deed of transaction.
Yes.
The Saint Thomas Community Hall, built by the petitioner, that is a which is not in district. So immediately I draw the attention of some court, the rejoinder which I have filed in the connected district.
Your S1 in the transfer document at page 108
Yes,
measures 1,140 square feet.
so based on those measurements shown here, we have calculated and
108 1,140 square feet ಅಂತ ಹೇಳಿದ್ರೆ. You are saying 44,000 square meters. 108. What is your title document that you are claiming?
108. Yes, one. Bounded on east to west, let's say north to south 530 feet into 425 feet. East to west 860 plus 120 plus 160 divided by 114.
Divided by 114.
It works out to 4,99,000.
Yes.
Kindly take the rejoinder which are filed in the connected expression of 4/9/2023. The corporation and sanction plan to put up this stability fund. That's an element.
Page
Page 7.
7 of the rejoinder.
This is the copy of the sanction plan. It's quite along the rejoinder.
Rejoinder to the statement of objections filed by respond 1 to 3.
16,860. Thank you very much.
Filed on 28/8/23.
7 September 20.
7 September. 2 rejoinder ಹಾಕಿದ್ದೀರಾ? 2 rejoinders. Filed one more rejoinder. Page 7. Yes.
Right. North is for main road. This community hall.
Main road.
Yes.
On the
West
north.
Road, property of Church of South India.
Yes.
Going by the very order of Procedural. Prosecutor get a 26th of the petition during the 16,857 schedule.
Now this is 50 feet.
So what I am trying to emphasize is, even though going their own schedule to the improved order regard, to the rest of the property which is the disputed property, the Saint Thomas Community Hall Institute, east of the disputed property, according to them, the improved order, it means Saint Thomas Samudaya Bhavan. Page 26.
The St. Thomas Center.
Is the Purvake, Ramata.
St. Thomas Samudaya Bhavana Purvake.
Yes. East, yes.
Ram Thaneyalliruva.
So going their own farm, it is sanctioned to be to put up construction blocks, the Samudaya Bhavan. The rest of this, it is shown as West Church of South India property.
Yes.
So what is to be inferred is the disputed property going by their own schedule not. It is the property which is in occupation of limitation. This plan was sanctioned at an undisputed point of time. 91. So my respect to subsidy not. No, they claim that this is not on a property of middle term wage. They are not put vested in the corporation. That is their statement in the statement of. To show that this property vested in the village panchayat, nothing is there. Some record show from 9 or 10th showing that this particular property vested in the gram panchayat and stood in the name of the government. And thereafter vested in the corporation. Nothing is made out.
All these things in a writ petition, we can't determine your title.
I agree with you.
I mean, if there is some document
There is a mechanism provided to understand.
which you can clearly show that this is your property is, by this kind of an interpretative argument, in a writ petition, we cannot set aside an order.
There is a mechanism provided. If such a claim is made on behalf of the corporation or against the corporation, a mechanism must be made. When we go to 178 of James. of claims to be, claims to the property by or against the corporation. In any city to which a survey of lands other than lands ordinarily used for purpose of residential only has been or shall be constructed on any law of the name imposed, where any property is claimed by or on behalf of the corporation or by any person against the corporation, it shall be lawful for the regional commissioner now of amendment of the inquiry of which the due notice has been given, pass an order deciding it. And any person accused by the order subsection 1 may appeal to the Karnataka appellate. Then we have the corporation, except the mutation of Kata subsequent to the improved order, showing the name as Katega. Nothing is present. In the statement of objections, they admit that we are in possession. They also admit that we hold Kata for all these properties, including strip 1. And as I already pointed out, going by their own boundary showing the improved order and taking into consideration the very plan sanctioned to me way back in the year 1981, depicts that to the west of the Samudaya Road, it is the corporation
So
property.
you had to approach the regional commissioner.
Now will be the deputy commissioner under the amendment. I put that out because for this reason. The deputy commissioner himself is the respondent. He himself passed an
No, this
order.
is the regional commissioner now. Earlier it was deputy commissioner.
2007 Act.
So 178A, if you are bringing into force, into is basis of your contention, then you have to approach the regional commissioner.
No, the order passes to the.
Which order?
Act Petition 168.
No, that is not what the challenge. I'll come to that up. No, that is under the 320.
Annexure A has been passed by.
In Petition 168.
No, that was under the old act, municipalities act. Right? That is also under challenge.
16.
Amendment is taken on both the petitions that one each refers
No, I am
to.
not speaking, sir.
In 16857,
Yes, sir.
you have challenged the order of
Not from the deputy.
third respondent. Third respondent is the deputy commissioner, the commissioner Mahanagar Palika. So in which, in the other matter,
Challenge the order of the regional commissioner. Earlier, what happened now, the representative of the then honorable minister, raising that the Katas have been paid without litigation. Actually, it is there.
no, virtually that is an order under 178.
No.
Annexure A is passed under which provision?
322 of the gold. Municipalities Act.
322 of the Municipalities Act.
Then this property.
Municipalities Act. So now if the order of respondent number 3 municipal commissioner has been passed,
Yes.
and if you are trying to invoke 178A, you will have to approach the regional commissioner because that was under 322, even if you accept that.
The order of the challenge in 16,869 was passed pursuant to the directions issued by this one. So the expert.
But that is only as regards the assessment and kata.
Yes.
That is not as, why are you invoking 178A? Your invocation of 178A.
And not the stand that there is not only for remedy. Now it's
Anyway,
the reason that my lord, for the reason that my lord has expressed that all these things cannot be decided in a petition. there are disputed facts. Right. My respected subject, I have already got a degree way back in year 1959. A declaration of title. I cannot be driven back to this before once again. That degree has attained finality.
Yes.
And there have been collecting passes. Repeatedly, the Kata stands in my name. The statement of objection, they say that I am going to be in possession. Possession is 8% in law, regardless of the fact that the Katas are made over illegally. Fact remains that in view of their own admissions that I am going to be in possession. If I am going to be in possession, whether such a land can be granted and transfer can be made in favor of the court respondent. Without due process, the alternative solution I will tell you.
Yes.
Regardless of that, they have taken up the standard interest statement, particularly the corporation judgment. The judgment which are obtained in the year 1957 is not a judgment in breadth. And the president of the society, the president of the corporation was made of the party. Commissioner ought to have been stood of the party. That is the contention they have taken. Whether such a statement can be made in a collateral proceedings of more than 70 years, without assailing the judgment and degree of the appellate court, it has granted me the degree of declaration and injunction.
Yes.
But I cannot, at this stage, Lord, I have a degree in my favor that is not assailed. I am going to be in possession in view of their own statements made in the statement. Whether it can be drawn back to the civil court once again. So, I cannot even be drawn to a situation where I have to approach the regional commission.
So you're not invoking 178A.
ಅದಕ್ಕೆ
ಕೇಳಿದ್ರು invoking ಅಂತ ಕೇಳಿದ್ರು.
You are not in the present justice to God. I am making this statement. If my lord were to hold that these disputed facts as of now on the basis of the records cannot be decided, the lordship can make a reference to regional commission to decide it within 2 weeks. I will cooperate with the authority. Let there be a joint survey. I will avoid by that. And come back to your lordship.
You have to go to KAT.
No. Keep the petition alive, pending.
Please make your stand clear what your stand is.
My stand is, I am in lawful possession. My possession and title was decided way back in the year 1990. That judgment still binds the Shimoga corporation. That is not assigned.
That is one stand. But what is it? What is your stand regarding 178A? You want to invoke or you don't want to? You are not. Oh, then it's a different. They will invoke.
My lord's power is
Reservoir of power. Yes. So your basic contention is that since there's a decree which has been passed already way back and the property's identity is not in dispute, the community all have been constructed by you after a license being obtained from sanction of plan and license being
The
obtained.
bound is depicted in the sanction plan. Shows that on the western side is the church property only.
Yes.
So to say that it is ground on a property, nothing is based on record to show that it vested with the panchayat before vesting to the corporation. After vesting also, except the khata which is made over in the name of the corporation, after the impugned order, nothing is based on record.
Yes.
They should have maintained a corporation. They should explain before the Supreme Court as to how they maintain the details of the corporation property. Remaining of this submission, I will request the Supreme Court to take this stuff second.
When did you file that? You filed it in which matter? 16,000? When did you file it?
First September.
First September. Really?
They're going to be
ILR 2002.
the 11th para is para 14. The property is defined. The property is exact, and I'm not going to allow it. The term of the
Yes.
corporation property. The provisional clause is exact. In the page number 11, any property which rests in the corporation by virtue of section 174 of the Corporation Act is held by the corporation as a trustee, and in its capacity as a trustee, the corporation is expected to deal with and apply only to subserve the purposes of the Municipal Corporation Act. The authority of the corporation is limited to acting as a trustee in the market. In order to subserve the interest of the resident at large of the corporation, being a trustee, the corporation had no legal right to batter away any property that came to be vested by it by virtue of operation of the Corporation Act to any third party. It does not become the owner as such of the piece of the land which vested it, so to say that it can deal with it in any manner as it deems fit. So my expectation is not just because the property is vested in the village panchayat and thereafter put vested in the corporation, they cannot be permitted to continue in the corporation unless they don't own title. They may have administrative system over the property. The first side doesn't mean that they are the owners of the property.
Then whose property is it?
It is the property of the petitioner, the public property.
It is a property in a Gram Thana, in a Gram Panchayat, which gets amalgamated with a corporation.
Yes.
But who becomes the owner? The corporation.
It is not the village panchayat alone is the owner of the property. The residents within the limits of village owns properties.
Have a right to use.
Right to, no.
Ownership of it.
So if they had in title in their cover by virtue of any document.
Yes.
If I own a house property in the village, it can be Gram Tada. It is Gram Tada property only.
Yes.
Regardless of the fact that whether it is a vacant site or with a dwelling house. If such property, if the panchayat were to establish title over the property, some document should have been there, showing that the panchayat is owner of the property, like form number 9 or form number 10. And if it's made over to corporation, it should have been entered in the register of the corporation.
Yes.
Nothing of campaign is placed on that. I have pointed out to my lord on the previous occasion, except that entry showing the corporation as Katedar in the year 2022, preceding that document, no document is made available to show that it is the corporation property. On the contrary, in the statement of objections, they admit that I own Katas for this property. I am found to be in possession. And the other statement they have made in the statement of objections is that in transfer deed, there cannot be a transfer. The deed of transfer which I am doing upon connection deed, there is no consideration, and as such there is no conveyance of title. For this reason, I have produced this statement. Paragraph 4. Secondly, the report of the deed of
Madras.
The owner of trustees of small proportion without the transfer the ownership of the land given to the Rajalakshmi Venuswamy charities is set trust without consideration. The trust therefore executed 2 documents of transfer and presented for registration on 20th December 2005. The documents, though kept initially as pending documents, for registered. The question before the court was whether the deed of transfer from one trust to the other trust would attract stamp. The reason that said no stamp is not attached.
Where is that finding?
Summary of submissions, the lodgement to be filed at page number 17. The findings recorded by the division is page number 22.
Para 18. The transfer of the subject is beyond the scope of Article 62E of the Stamp Act. In order to give a definition of the transfer under the Article 62E, as suggested by the respondent, you must either add words to the problem or read words which are not there at present. The courts cannot presume that there is an omission in the word used by the legislature. It needs incorporating the factual word, which is the opinion of the court, best suit to give a wise interpretation. The runner judge proceeded as if Article 62A would attract transfer of property from one trust to another trust. It is not possible to use such interpretation to Article 62E in the present form. We are therefore conclude that the appellants are entitled to such a for the first people. In the word of the transfer of property.
Indian Stamp Act. What is 62E?
62E. The tax transmitting.
Article 62.
First time, the title suit, they are not taken up these contentions. First time before the Supreme Court, they said that the deed of transfer does not convey title. This, it is not, there is no consideration possible right now. For that reason, I am relying upon this.
Transfer with or without consideration of any trust property without consideration from one trustee to another trustee.
Okay.
To or from a trustee to a beneficiary.
So in the case set against last I could brought, the transfer was from one trust to the other trust. There are 4 of them. There can be a transfer from one trust to another trust without consideration. Nevertheless,
But section Article 62E is of any trust property without consideration from one trustee to another trustee.
that is what the division bench of the other.
See, it may be that a trustee is holding a property of the trust in trust. The second trust created in that trust.
Nevertheless,
And one trustee in the in-on trustee will, that second trustee will hold it in trust for the trust. Then there is no stamp duty payable, may sound proper.
my only submission is that
You are extending it further from one trust to another may not be in 61 EL, 62 EL, but there would. That's not been considered in this matter. Yes, anyway, let us see what they say. So your contention on the basis of this judgment is that transfer from one trust to the other trust is also
need not be for consideration.
need not be for consideration.
This difference was not put forth in the title suit. Now cannot, they cannot be permitted to contend in the Karnataka proceedings like this.
Yes.
The third judgment of that I am not, I'm very well complicated.
Yes.
Para number 21. And The principle enshrined in section 107 of the Evidence Act is based on public policy with the object of preventing persons from committing breach of peace by taking life into their own hands, or with their right to own the lands in possibility. It is this purpose that the provisions of section 6 of the Civil Act states that the unprotected introduction into the and notice to enacted. All the opposite provisions are the same object. The said presumption is replicable. But 114 of the Evidence Act and applies only in a case where there is either no proof or very little proof of ownership on either side. The maximum of possession follows title is applicable in cases where proof of partial possession cannot be reasonably be expected. For instance, in the case of waste lands or where nothing is known about possession, no one way or another. Presumption of title as a result of possession can arise only where facts disclose that no takes place in any part. Origin of the plaintiff is not previously wrongful. The right and the plaintiff is not true. It certainly does not mean that because the man has taken over some land, he is necessarily in possession of it. In fact, means that if any point time a man with title was in possession of that property, he allows that presumption that for possession in continuation of the title vested in him. The person must set off with that he has continued possession of this property, while the other side may be taking but make out a case of trespass, enforcement, etc. When the apparent title is plaintiff, it is incumbent upon the defendant in order to displace his claim of apparent title and to establish beneficial title in himself must establish by way of satisfactory evidence circumstances that favor in version. Even a revenue record is not an option. So, the establish that I may not for the activity of speculation of right. Revenue records are made available on the basis of the transfer deed. And
What documents have you produced to show you are in possession of this land?
yeah, admittance in statement of it.
Yeah.
Government admits a lot time I have pointed out.
Yes.
And they also admit us to the mutation of Khata on the basis of the deed of transfer in my favor. The measurements which are produced along with the affidavit are in conformity with the measurements which are before in the transfer of deed of property. To displace this evidence which are there for the storm to disprove it, the respondents have not made any attempts to show that the property which they have transferred into the improved order is the corporation property. Corporation holds straight to the property. From transfer from Milagata Gram Panchayat to our city corporation, there should have been some procedure. Initially, it should have been vested in the Gram Panchayat. Thereafter, it would be vested in the corporation blood. There should have been some document. There should have been entry in the corporation register. For last 70 years, there are no entries in the corporation. Only after the improved order, they have made an attempt to mutate Khata in the name of the corporation. Whether that only document could be accepted at this stage to show that it is the corporation who owns the property and it is the person of the property, can't be statement with the in statement. That is best.
Banu Prakash. Which one?
The other petition not. After the claim order.
ಮುಗಿಸ್ಬಿಡಿ ಆಮೇಲೆ ಅವರು ಮಾಡ್ತಾರೆ 16866
Yes. That's the reason. This order is passed over pursuant to the directions issued by the Sound Court in WP number. I have not reviewed the order. The respondents have to do that. May I make it the rush? Often, but
Where is that order?
annexure A is the order.
What do you want to read? This court's order or the impugned order?
Include order.
Yes.
Meeting petition filed before the competent authority and pre-petition, by then the property vested with the municipality. The progress of municipality is not. But the order came to pass pursuant to the directions of the Sound Court, remanding the matter to the competent authority to hear the party afresh and pass an order in that part. That order is also placed on the file by the respondents. Annexure R19, the statement of objections.
Page 92.
Right by. The connected.
Yes.
This is zero problem. Page 98. Yes, sir.
2018 order, 2011 petition. Yes.
Page 98.
Yes.
This repetition was filed by Lord. Church of South India represented by its forward army holders, Mr. Vijay Kumar Gandin and Pongeshwar. This is important. Somebody else represented the. So these two persons are the forward army holders. They are going to speak.
Who is representing them now?
Oh, I am representing them.
Vijay Kumar Dandin and
Yes, yes.
Satyababu Sangre. And DT Kone Sagar. Vijay Kumar Dandin is common.
Yes.
Yes.
CM Nagpur to learn counsel for the petition ultimately content with the impugned order passed by the deputy commissioner without giving notice or without getting petitioner in the letter violation of the principle of naturalization. Though the review petition came to fed for the deputy commissioner, who in turn rejected the same on the ground that already an order has been made by the same authority, even though the petitioner was not party to annexure A. On the earlier occasion, the petitioners before the South Court represented by Ishwan were not parties before the deputy commissioner. Somebody else misrepresented the deputy commissioner and obtained an order. So that was challenged before the South Court in the petition. He would further contend that the order dated 21/1983 passed by the third respondent commissioner of municipality holding the petitioner in the absolute power in position and therefore either is the public or the third respondent corporation has any right over property in question. When the rights of the parties involved in respect to remove property, the deputy commissioner ought to have issued notice to the petitioner and ought to have heard before passing the order, but the same has not been in resource. So that was contention. When you go to page number 10, file number 10.
Third respondent is the CMC, Shumaga. At that point of time.
Third respondent is CMC. File number 11. Having heard the learned counsel of the parties, it is specific case of the petitioners that Wesleyan Methodist Missionary Trust Association has excluded a trust deed as per Annexure D in favor of petitioner on 12/6/1963, and since then the petitioner has been in possession and enjoyment of the properties, having assigned different Khata numbers as stated supra. It is also not in dispute that the petitioner association has sold all the sites found by the petitioner as per the National Code in favor of the city. It is also not in dispute that the complaint made by the fifth respondent L. Adishesha, along with M. Sampath, the jurisdictional commissioner, Shumaga Municipal Council, registered a case bearing number C4CR 1994 of 1992, after holding detailed inquiry and after hearing both the parties, a detailed alternate 21/1/1983 held that the present petitioner Church-Association Association is the owner of the property in question, based on the document proposed, and said properties do not belong to the municipality or the public property. But I read over to this art passed by the very commission. He himself, on the basis of the complaint, holds inquiry, and the records are finding that it is not the corporation property, it is the property belonging to the petitioner. Therefore, the objections filed with the third respondent and another was rejected. The set out passed by the third respondent, Commissioner of City Municipal Council, with the jurisdictional authority has attained finality. Though the relevant council of the party sought to testify that the property belongs to the government, it is not the case of the state government or Tahsildar, either deputy commissioner or before this court that the property belongs to the state government. That's the finding. Not a conclusive finding drop in some court. They don't want to take undue advantage of finding. Nevertheless, they did not lay any claim on the previous occasion also before the Sound Court that it is the corporation property or the government property. Even if it is the property of the state government, the authorities have to give opportunity of being heard to the aggrieved affected party and then only has to proceed to pass the orders. Even though the valid counsel for the petitioner sought to justify that the deputy commissioner had given opportunity to the petitioner, it cannot be accepted merely on the ground that, as per annexure here, the art passed by the Commissioner City Municipal Council clearly depicts that the petitioner was a church association represented by the General Power Attorney Holder C. Vijay Kumar Gandhi, and fifth respondent was the first respondent, and one MT Sampat was the second respondent. According to Mr. Prasad, valid counsel for the respondent file, as per annexure A, one C. Yesudas, chairman and president of the Trust of South India, Trust of Shimoga, are one and the same, as the petitioner did not produce any material document before to show that the present association with the state association are one and the same. The valid counsel of the petitioner asserted that State Yesudas has nothing to do with the present petitioner, and he is no way concerned with the property question. Even though State Yesudas made as a party to the proceeding, he has remained served and unrepresented. There is no dispute with regard to the assertions and don't serving in the petition by any of the respondents by filing interstatement except justifying into the order of the deputy commissioner. A careful perusal of the order actually clearly depicts that the deputy commissioner has not issued any notice or opportunity of being heard for possibly include order. Though the review petition can be filed as the present petitioner, it came to dismiss on the ground that he had already passed an order which amounts to restitution. The specific contention was taken by the present petitioner for the deputy commissioner that the first respondent therein, that is the fourth respondent case law, is not authorized by the petitioner for representing in the proceedings. He does not have any list for employer and employee, and also is taken to the trust and petition of this. It was specifically alleged that association was heard in the proposed proceedings, which has resulted in miscarriage of justice. The art passed by the tribal authority should be visual authority. On 28/2010 is done in the of justice. The deputy commissioner, though recorded the contentions, has not considered the said contentions and has rejected the petition only on the ground of review. Therefore, input or passed deputy commissioner for actually is without notice and without holding an opportunity of being heard. Therefore, the deputy commissioner ought to have holding an opportunity of being heard. And since the rights of the parties are important in respect of legal property, it affects the civil rights of the party, but the same has not been done. So the business stated above, petition allowed. Consequently, of the second report are here class. The matter is reflected. The commission for the matter of fresh. It is the right of this other past by some for not the matter was taken by the division of the and the past do not produce the correction. So, under the improved order, the authority records the contents of parties. And never records any finding as to the contentious put forth by the parties. Then you go to page number 25, paragraph 13.
Yes.
ಮೇಲೆ 40ನೇ ಸಾಲದಲ್ಲಿ ನೋಂದಣಿ ಮಾಡುವ ದಸ್ತಾವೇಜಿನಂತೆ ಹಕ್ಕು ಸ್ವಾಮ್ಯತೆ ಪಡೆದಿದ್ದು ಸದರ ದಸ್ತಾವೇಜುಗಳು ತುಂಬಾ ಹಳೆಯ ದಾಖಲೆಗಳಾಗಿರುವ ಕಾರಣ ಮತ್ತು ಸರ್ಕಾರಿ ಕಚೇರಿಗಳಲ್ಲಿ ಶಾಶ್ವತ ದಾಖಲೆಗಳು ಲಭ್ಯವಿರುವುದಿಲ್ಲ ಸಂಬಂಧಿಸಿದ ನೋಂದಣಿ ಕಚೇರಿಗಳಲ್ಲಿ ಈ ದಾಖಲೆಗಳು ಲಭ್ಯವಿರುತ್ತದೆ ಹಾಗೂ ಸದರಿ ಟ್ರಸ್ಟ್ ಅವರು ರಾಜ್ಯಾದ್ಯಂತ ಲಭ್ಯವಿರುವ ಆಸ್ತಿಗಳನ್ನು ಬೆಂಗಳೂರು ನಗರದಿಂದ ಪೂರ್ವದಲ್ಲಿನ ಕಚೇರಿಯಲ್ಲಿ ನೋಂದಣಿ ಮಾಡಿ ಹಾಗೂ ಸದರಿ
Just one moment. Mr. Vasraj, your cost title reads as a company registered under the Indian Companies Act.
you have to find the standard
You are saying trust.
and trust.
You are called Church of South India Trust Association,
Yes.
but you are a company registered, section 8 company.
Not this issue of for the sample, the division bench bar. Lordship Justice Kumar has concluded that it is a trust.
You are you are a section 8 company.
Yes, and a scheme is also formulated. That is before the school board. I will place that gentleman. And
Then were you registered in 1963 as a company?
nothing for that. The transfer of company was registered but before being independent.
Westland Methodist Church is a trust. But when the transfer happened in 1963, according to you, in whose favor was the transfer done?
It's also being that is.
Trust antide illi company antide. Was this company, when was it registered?
Company is registered in the year 1970. 1970.
So 1963 yaar favor al transfer aayತು.
There are the petitioner only.
When did the petitioner come into being?
Then it was a trust. The date of transfer to that trust.
So that trust in the company ಹೆಂಗ್ ಬಂತು? How did the flow of title happen between the trust and the company? That you have not explained anywhere till now.
Transfer.
Because we are seeing the order and the writ petition. There also it was a company. The last portion only, a typing mistake ankondi, but it's not a typing mistake. It's a company.
It's given by last one.
You have stated you are a trust, you are a company, you are an association in that order. There are 3 different descriptions. 61 of?
This petition is also 1913 Indian company since 1913.
61.
This document consists of 15 sheets of the data.
Yes.
This document consists of 15 sheets of the data. This signature made on the zone between Western Methodist Trust Association incorporated in the English company. Having its office also. On one part, Church of South India company incorporated the objections to blood have been addressed for the union.
Under 1939.
Yes.
Nineteen 1929 is the English Companies Act.
1930.
1930 is the Indian. So you are registered as a not-for-profit company under the 1913 Act. Yes.
And this also said that the petition.
We don't know. ನಿಮ್ಗೆಲ್ಲ ಗೊತ್ತಿಲ್ಲ. ನೀವು ಹೇಳಿಲ್ಲ ಅಂದ್ರೆ how will we know? You are the master of your facts. We will go by what you tell. Yes. We are only because in that matter, you have been described as a trust, as a company and as an association. That's why we got it out.
The petition authority wants to demand having
ನೀವು ಓದ್ತಾ ಇದ್ರಲ್ಲ ಮುಂದುವರೆದು
ಹಾಗೂ ಸಭೆ ರಾಜ್ಯದಿಂದ ರಾಷ್ಟ್ರಗಳು ಬೆಂಗಳೂರು ನಗರದಿಂದ ಕಚೇರಿಯಲ್ಲಿ ಮಾಡಿ ಹಾಗೂ ಸದರು ಹೆಚ್ಚು ಸೌಲಭ್ಯಗಳ ವಕ್ತಾವಿನಲ್ಲಿ ಸಭೆಗೆ ಸೇರಿದ ಆಸ್ತಿ ಬಗ್ಗೆ ವಿಸ್ತೀರ್ಣದ ಬಗ್ಗೆ ಸ್ಪಷ್ಟವಾಗಿ ಚರ್ಚೆ ಬಂದಿರುವುದು ಹಾಗೂ ಸದರಿ ಆಸ್ತಿ ಈ ಪೂರ್ವದಲ್ಲಿ ಎಸ್ಡಿಎನ್ ಮಿಷನರಿ ಟ್ರಸ್ಟ್ ಅಸೋಸಿಯೇಷನ್ಗೆ ಸೇರಿದ ಆಸ್ತಿಗಳ ಆಗಿರುತ್ತವೆ ಎಂಬುದಕ್ಕೆ ಪೂರಕ ದಾಖಲೆಗಳನ್ನು ಆಗಬೇಕು.
We'll do and we'll come back and we have another division bench at 2:30. I think we'll finish and some probably in half an hour and so agate. 57. When do you want it? 57 at the request of counsel for the petitioner relist on 6th November. 69. Interim order is acceptable. EVR. Yes, have you informed the petitioner? Petitioner inform ಮಾಡಿದಿರಾ ಮೆನ್ಷನ್ ಮಾಡ್ತಾ ಇದೀನಿ ಅಂತ. ಇವಾಗ ಮೆನ್ಷನ್ ಮಾಡ್ತಾ ಇದೀರಾ ಅಂತ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದೀರಾ petitioner ಗೆ? ಅರ್ಥ ಆಯ್ತಪ್ಪ, ಬಟ್ ಇವಾಗ ಮೆನ್ಷನ್ ಮಾಡ್ತಾ ಇದೀರಾ ಅಂತ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದೀರಾ? Don't mention without inform. When it reaches.
ಫಿಫ್ಟಿ-ಫೋರ್ತ್ ಮ್ಯಾಟರ್ ಇಟ್ಕೊಂಡಿದ್ದಾರೆ ಕೋರ್ಟ್ ಆಫೀಸರ್. ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್. ಸರ್ 54th ಮ್ಯಾಟರ್ ಇಟ್ಕೊಂಡಿದ್ದಾರೆ.
ಡೈರಿ ಹತ್ರ ಮಾತಾಡ್ತಾರೆ, ಬರ್ತಾರೆ.
ಹೇಳಿ.
54th ಮ್ಯಾಟರ್ ಇಟ್ಕೊಂಡಿದ್ದೀರಾ?
54 ಇದೆ ಸರ್, ಅದು ಇನ್ನೂ ಕರೆದಿಲ್ಲ.
ಓಕೆ ಓಕೆ.
54 ಅಲ್ಲಿ ಇದೆ.
ಅದ್ ಗೊತ್ತಾಯ್ತು. ಅಲ್ಲ 54 ಬೆಳಿಗ್ಗೆ ಏನಾದ್ರು ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ತಗೊಂಡಿದ್ದಾರ ಅಂತ.
ಇಲ್ಲ ಸರ್, ಇದೆ, ಅದು ತಗೊಳ್ಳಿಲ್ಲ.
ಬರ್ಲೆ
ಮೇಡಮ್ ಧಾರವಾಡ ಬೆಂಚ್ ಇಂದ ಆಡಿಬಲ್ ಇರೋದಲ್ಲ ಮೇಡಮ್?
ಹಲೋ, ಕೋರ್ಟ್ ಆಫೀಸರ್.
ಹೇಳಿ ಸರ್. ಸರ್ ಹೇಳಿ.
ಸಿಟ್ಟಿಂಗ್ ಇದೆ ಅಲ್ವೇ?
ಹಾ ಇದೆ ಇದೆ, ಡಿವಿಷನ್ ಬೆಂಚ್ ಅಲ್ಲಿ ಇದ್ದಾರೆ ಸರ್.
ಹೌದಾ?
ಮೇಡಮ್ ಇನ್ನೊಂದು ಸ್ಮಾಲ್ ಇನ್ಫಾರ್ಮೇಶನ್ ಬೇಕಿತ್ತು.
ಹಾ ಹೇಳಿ.
ಮೇಡಮ್ ಬೆಳಗ್ಗೆ ಪಾಸ್ ಕೇಸಸ್ ಇತ್ತಲ್ಲ 80 ವರೆಗೂ ಲಿಸ್ಟ್ ಆಗಿತ್ತು, ಅದು ಮಧ್ಯಾಹ್ನಕ್ಕೆ ತಗೊಳ್ತಾರ ಮ್ಯಾಮ್?
ಈಗ ಫಸ್ಟ್ ಬಂದ ತಕ್ಷಣ ಡಿವಿಷನ್ ಬೆಂಚ್ ಇದೆ ಇಲ್ಲಿ.
ಓಕೆ.
ಅದಾದ್ಮೇಲಿಂದ ಒಂದ್ ಮ್ಯಾಟರ್ ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 44 ನಡೀತಾ ಇತ್ತು, ಅದು ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ.
ಓಕೆ.
ಅದಾದ್ಮೇಲೆ ಫಾಸ್ಟ್ ಓವರ್ಸ್, ಆಮೇಲೆ 230 ಮ್ಯಾಟರ್ಸ್, ಆಮೇಲೆ ಲಿಸ್ಟ್ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ.
ಆಮೇಲೆ ಲಿಸ್ಟ್ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತಾ? ಓಕೆ ಮ್ಯಾಮ್, ಥ್ಯಾಂಕ್ ಯು.
ಯಾರಿದ್ದಾರೆ? ಅದೇ ಲಿಸ್ಟ್ ನೋಡ್ಕೊಂಡು ಬರ್ದೆ. ಬರ್ತೀರಾ ನಾಳೆ? ಹಾಕ್ಲಿಲ್ಲ ಅಂತಂದ್ರೆ ಅದಕ್ಕೆ ಬರೋದ್ ಬಂದಿದ್ದೀರ ಪರ್ದಾಕ್ತು. ನಾನ್ ಮಾಡ್ಬೇಕು ಕಡೆಗೆ. ಅಲ್ಲ ಲಿಸ್ಟ್ ತಗೊಂಡ್ ಬನ್ನಿ. ಲಿಸ್ಟ್ ತಗೊಂಡ್ ಬರೀರಿ. ಧಾರವಾಡ. ಇಲ್ಲ ಫಸ್ಟ್ ಅದಾದ್ಮೇಲೆ ಇದು ಇದೆಲ್ಲ ಇದ್ರು ಸರ. ಈಗ 2-3 ಮಿನಿಟ್ಸ್ ಹಿಂದೆ ಇದ್ರು. ಈಗ 2-3 ಮಿನಿಟ್ಸ್ ಹಿಂದೆ ಇದ್ರು.
This one, 30th of October. Same. Same. Inform.
ನಮ್ಮ ಈ ಡಿವಿಷನ್ ಇದೆ ಅದಿದೆ ಅಂತ ಹೇಳಿದ್ರು.
By additional evidence, effective the measurements of the property.
Additional affidavit filed in? ಯಾವ್ದ್ರಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದ್ದೀರಾ? That is 27/9. Yes.
Objections is filed by the third respondent property.
Petition file like. Objection again. When was that objection filed? When was it filed?
26/9.
Nimdo 27/9. Your affidavit is 27/9.
They have filed objections. My memo of calculations of 26/9.
Memo of calculation. Memo of calculation was filed on?
It is not accompanied with the memo.
Memo of calculation was filed on 25/9.
Yes.
And for that, the objection was filed on 26. Yes.
It is submitted to the dimension in the memo details, so it's not fully correct. Properties mentioned at S1 to S8 relate to properties situated within the mission compound. So there is an attention to say that S1 to S8 all the properties are within the mission compound.
Yes.
Mission compound is the property where the entire properties of sections of the yes. And there is a declaration of title and injunction in my favor in respect of these properties, which are attained to.
You have given the measurement of so many properties, that's why they have said that.
Yes, yes.
9 to 15 is not connected. So 9 to 15, what is your?
Associated elsewhere. That is my, not my case.
Madhyana
It is not, no. To know that the S1 to S8 properties are situated within mission property. And the disputed properties is S1. That is the.
S2 to S8 is not disputed.
No, though S1 to S5, S8 are the petitioner's properties. Now the disputed property, which is start to be transferred in favor of both respondent, is S1.
What about S2 to S8?
S8 are adjoining properties.
That you continue to be in possession of.
Yes, is there admission also stated about it?
Yes, and the name of now here.
Cost of reputation,
So 9 to 15 are outside the compound somewhere else. They are saying 2 kilometers away. Is that
Yes,
it?
yes. There is no dispute.
Yes.
So then may cost of once again, may take the statement of objections where they are admitted to a publisher. Right by the state.
ಅಲ್ಲಿ ಆಗಿರ್ಲಿಲ್ಲ ಈಗ ಆಗಿದೆ.
That is in 16,857.
Yes.
Para number 16 of the statement of objections. It is respectfully submitted that clarification.
Yes.
As on the year 2015-16, the petitioner is shown as Katedar with respect to 11 properties to an extent of 11 acres 33 acres. As per the records maintained in Corporation Somaga, as per Annexure R9, report paper, when such is the circumstance, a measure recently of the so-called property of the petitioner through the Corporation Surveyor discloses that the petitioner are in possession of an extent of 18.35 acres. Acres of land against an extent of 11.50 acres of land as per Kata. Again, a column 18. Yes. It submitted that the petitioner heavily relies on the layout plan sector to produce the OS number 135 of 59 to claim ownership over the property. And the same was marked as H59 in said case. The said layout plan is now available and produced as Annexure 11. The petitioner has listed out the properties in Annexure B of WP. They are described as S1 to S9 in the said annexure and are shown as R11. Exclude close scrutiny at the same makes property clear. The property identified in the purpose of capital operating comes outside the property of S1 to S9. That is the contention.
Basically, essentially, as what we told you first time, there's a issue about identity and the location of the property.
Yes, exactly.
You are claiming that it is this S1 to S8. They are saying it is not S1 to
One
S8.
particular document which I have pointed out, the sanction plan, in the year 1991, it showed us that on the western side of the community hall, it is the success of India.
Maybe so.
It was sanctioned at an undisputed point of time.
But western portion could be this side or that side.
Western portion, if their own schedule to be accepted as correct in the grant order law, east by community hall.
They are not claiming anything on S1 to S8. They are not claiming anything on S9 to S15. S9 to S15 are located somewhere else 2 kilometers away.
S9, no, S9, S15, they have no
S1 to S8 is the only issue.
Yes.
S1 to S8, they are saying is not what they are claiming. They are saying they are not claiming S1 to S8 unless they say.
No, see, again, the sketch which they have produced, along with the interest statement, the proposed area which is sought to be transferred comes within S1.
Can we say that in a writ proceedings? That what they are claiming is coming in S1 and what they are saying is wrong and Telakagata. Without evidence being laid on that, can we say that? On what basis do we say that?
The only basis could be not, in my respect to submission. The boundaries go in the land.
That's a very vague. Very on the western portion. That this one is convention center is located on our basis.
After that, site number 17.
Very difficult for this court in writ jurisdiction without evidence being on record to say that.
That part is not. Already considered that the corporation based applying in respect of any portion of property, whether it is Ramtana or corporation property, what is that they have to do?
They have to go to the regional commission.
If the property is restricted to the village website, they should have had some document either in the column of 9 or 10. And after transfer to the corporation, testing of the properties in the corporation, the property list should have been made. Right from 1922-23, there was no document to show that in respect of this property which is being transferred or granted, whatever it is. There is nothing to show on record that it is the corporation. The Khata number which they have assigned is 1159 is of year 22-20. Preceding that document, there is no document here.
Let's see what. Anything else?
And 16,000, the other question I was asking. Number 25. Was it AIT of trying to find out before that I have list number 2 of page number 25.
Yes.
ಅರ್ಜಿದಾರರು ಮತ್ತು ಎದುರುದಾರರ ವಾದ ಮತ್ತು ವಕೀಲಾಪಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ದಿನಾಂಕ 24/7/2005 ಆದೇಶ ಕಡಿಕೆ 11 ಸರ್ಕಾರಿ ಜಮೀನು ಆಗಿರುವುದಿಲ್ಲವೆಂದು ಹಾಗೂ ಸದರಿ ಸತ್ತುಗಳ ಚರ್ಚಾಸಮಿತಿಯ ಟ್ರಸ್ಟ್ಗಳಿಗೆ ಸೇರಿದ ಆಸ್ತಿಯಾಗಿತ್ತು ಎಂದು ಗಮನಿಸಲಾಗಿದೆ. ಹಾಗೂ ಮಾನ್ಯ ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯದ ಆರ್ಯ ಹೊಂದಿರುವ ದಿನಾಂಕ 8/1964 ಆದೇಶದಲ್ಲಿಯೂ ದಾವೆಯಲ್ಲಿ ಒಳಗೊಂಡ ಸೊತ್ತು ಟ್ರಸ್ಟ್ಗೆ ಆಸ್ತಿ ಎಂದು ಘೋಷಿಸಲಾಗಿದೆ. ಆದರೆ ಈ ಪ್ರಾಧಿಕಾರದಲ್ಲಿ ವಿಚಾರಣೆಗೆ ಹಾಜರಾಗಿರುವ ಶ್ರೀ ವಿಜಯಕುಮಾರ್ ಬಿ ಬೆಂಗಳೂರು ಸದರಿ ಟ್ರಸ್ಟ್ ಎಂದು ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಶಿವಮೊಗ್ಗ ಜಿಲ್ಲೆಯವರ ಒಂದು ಅರ್ಜಿಯನ್ನು ದಾಖಲಿಸಿದ್ದು ಮೇಲ್ಕಂಡ ಅರ್ಜಿದಾರರಿಗೆ ನೀಡುವ ಸಿಪಿಎ ಅಥವಾ ಇತ್ಯಾದಿ ಪೂರಕ ದಾಖಲೆಗಳನ್ನು ವಾದಿಸಿದ ಕಾರಣ ಸದರಿ ಟ್ರಸ್ಟ್ ಪರವಾಗಿ ಅರ್ಜಿದಾರರಿಗೆ ಅರ್ಜಿ ದಾಖಲಿಸಲು ಯಾವುದೇ ವಾಪಸ್ ಕೇಸ್ ಆಫ್ ದಿ ರೆಕಾರ್ಡ್ erroneous credit. But these very petitioners, petitioners represented by the Proceedings, they did not dispute us to their loans. This all court entertained the request, remanded the matter. The same persons were before the regional authority.
It might not have been raised there, they're raising it here.
Right?
The issue was not raised.
No, how can we?
Now you are a company. You are a company. Is there a board resolution? At least. Board resolution is better. In what manner is the company represented on order 30?
In the request is not this power on your foot. There is a pending recorded.
Where is the power of attorney?
Power on is produced. We collected the question. Then what we do?
How have they been authorized? Is there a board resolution?
The power attorney. Jointly involved with the authority or the government in mandate to be who and lawful attorneys to transact and manage all the affairs of the business. The section is saying Karnataka and Andhra Pradesh and person all or any of the following articles.
If we go by this, your petition itself will go.
No, petition, clause number 6, man. To appear for and represent the association in all courts and before all judges, justices, magistrates.
If you read this, association doth hereby nominate and constitute Martin Bogai or any one of the following to be nominated by him for each individual transaction. Following are to be nominated by him. That nominee is Vijay Kumar Dandan, who has now filed it. Satya Prabhu Samuel, Anand Sadguna Paul, jointly or two of them with the first attorney. So without the first attorney, it cannot be filed. Or is Yelli there? Martin Borgai is not party to this. Where is Martin Borgai is not here. Jointly or two of them with the first attorney or his nominee, being mandated to be its true and lawful attorneys. But this is a company without a resolution. A power of attorney cannot be. There's no mention of any resolution also. How do we accept this power of attorney? They are not directors. They are not directors of the company. Even a Section 8 company requires a director. Trust Allah. This is a company. Company registered under 1913 Act as a not-for-profit. All concomitants of a company are required to be followed by this not-for-profit also. What was Section 26 and Satya? 1956 Act. It is 1956 Act. Now it is Section 8 company under 2013 Act. 56 Act. The board resolution is required even for that.
And I am making last question of this. How it works.
Section 25 of the Companies Act 56. Section 25 company, Section 8 company, and 1913 al section of the But there should be a board resolution to authorize.
Now it is the South Court has read the trust act is trust.
It cannot be a trust. There's no finding. It is not a list and dispute. It's only a contention which is recorded. But anyway, now they haven't argued. That's not the question now. The question is because in Annexure A, the power of attorney issue has been raised. For that, at least you should have produced a board resolution that you are authorized. Now that it is raised.
Oh, whether that issue can be addressed now also.
If you don't produce anything, then there's nothing on record. There's nothing on record.
And I request.
The 1913 Act. 56 and section 25. 56 Act of section 25. 2013 Act of section 8. 1913. There's some section there. For a charitable trust. Association to be registered for charitable purpose and license to be issued by the central government for that purpose.
There is, I have placed on record a document, the constitution of the Church of South India. There are 25 dioceses, 24 dioceses.
It may have, dioceses are like branches. They may have 100 dioceses, that's not a matter. But the functioning of this company, you'll have to read up what section 25 and section 8 is. There's a license given by when a charitable institution, not only a religious, charitable institution, lot of educational institutions are also under section 8. If something is to be registered, Income Tax Act and the permission for water, license for central, then the usage of the word limited or private limited is exempted. But they have to file returns under section 10 of the Income Tax Act and this one. All those things have to be satisfied. So that is what those are. But essentially, it still functions as a company. Anything that has to be done is required to be done as a company. Therefore, there has to be a board resolution. Filings have to be there. The power of attorney without the board meeting, who is authorizing whom? Being represented by secretary. Secretary authorizes some person. What is this authority?
Proceedings of separation,
Where is the constitution? What is the? You'll have to make good this because that has been raised. Anything else?
What I am trying to submit is the regional authority will not have to be demanded. The fines part will be packed into power of attorney.
Power of attorney itself is not proper and now it's there.
Power of attorney was produced in writ petition. So the remand order. Pursuant to the remand order, the regional authority could not have found fault with the fact that the power of attorney.
Yes. Yes.
Next paragraph. ಇದುವರೆಗೂ ಪ್ರಸ್ತುತ ಸ್ವತ್ತುಗಳು CS ರವರು 1963ನೇ ಸಾಲಿನಲ್ಲಿ ನೋಂದಣಿ ಮಾಡುವ ದಸ್ತಾವೇಜಿನಂತೆ ಹಕ್ಕು ಸ್ವಾಮ್ಯತೆ ಸದರಿ ದಸ್ತಾವೇಜುಗಳು ತುಂಬಾ ಹಳೆಯ ದಾಖಲೆಗಳಾಗಿವೆ. ಸರ್ಕಾರಿ ಕಚೇರಿಗಳಲ್ಲಿ ಶಾಶ್ವತ ದಾಖಲೆಗಳು ಲಭ್ಯವಿರುವುದರಿಂದ ಸಂಬಂಧಿಸಿದ ನೋಂದಣಿ ಕಚೇರಿಗಳಲ್ಲಿ ದಾಖಲೆಗಳು ಲಭ್ಯವಿವೆ. ಹಾಗೂ ಸದರಿ ಪ್ರಸ್ತುತವು ರಾಜ್ಯಾದ್ಯಂತ ಲಭ್ಯವಿರುವ ಆಸ್ತಿಗಳನ್ನು ಬೆಂಗಳೂರು ನಗರದಲ್ಲಿ ಉಪನೋಂದಣಿ ಕಚೇರಿಯಲ್ಲಿ ನೋಂದಣಿ ಮಾಡಿದೆ. ಹಾಗೂ ಬರುವ ಸ್ವಾಮ್ಯತೆ ಪಡೆದ ದಸ್ತಾವೇಜಿನಲ್ಲಿ ಸದರಿ ಕಚೇರಿ ಸೇರಿದ ಆಸ್ತಿಯ ಬಗ್ಗೆ ವಿಸ್ತೀರ್ಣದ ಬಗ್ಗೆ ಸ್ಪಷ್ಟವಾಗಿ ಚೆಕ್ಕುಬಂದಿರುವುದು ಹಾಗೂ ಸದರಿ ಆಸ್ತಿಗಳು ಈ ಪೂರ್ವದಲ್ಲಿ ವೆಸ್ಟಿಯನ್ ಮೆಥೋಡಿಸ್ಟ್ ಮಿಷನರಿ ಆಸ್ತಿಗಳಾಗಿದ್ದು ಎನ್ನುವುದಕ್ಕೆ ಪೂರಕ ದಾಖಲೆಗಳು. This document was the subject matter of suit for declaration way back in India. How the title was derived upon the petitioner before this court was decided by the competition. Whether the constitutional authority can sit over such finding of the Supreme Court and say that how the property was devoured upon the petitioner and no such document is made available, and the document which was not made available does not describe as to how the state was derived upon it.
Yes.
This finding of the legal authority is not so erroneous in the case of. ಆದ್ದರಿಂದ ಪ್ರಸ್ತುತ ಸ್ವತ್ತುಗಳ ಹಕ್ಕು ಸ್ವಾಮ್ಯತೆ ವಿಚಾರದಲ್ಲಿ ಸಕ್ಷಮ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಪರಿಹಾರ ಪಡೆಯುವುದು ಸೂಕ್ತ ಎಂದು ಪುನರ್ ಪರಿಶೀಲನಾ ಪ್ರಾಧಿಕಾರವು ಒಪ್ಪಿದೆ. Again, he wants to, the legal authority wants to brave act to. The first case not the authority could not have found fault in the fact that power was. In the second case not, having regard to the fact that I have already got a degree of declaration of title and possession. Injunction, not post injunction. And my title to the lands in question, that is 2.8. So the subject matter goes to legal authority. The authority could not have sat over the finding list and could not have directly originally not negotiated.
Yes.
To re-educate. But this finding of the legal authority, this order has to go.
Yes. Writ petition has to be allowed and this order has to be caught.
The giving authority blood, having taken cognizance of the fact that not the very commissioner of the corporation. At one point of time, on the allegations of fabrication of documents and data, held inquiry. And he drawn.
74.
It is the property of Church of India and it is not the property of the corporation. That charge has attained finally. That apart, the matter was investigated by CID. The finding is recorded of the investigation. They are the CID had gone into the records of the corporation. Now found that Aadhaar are available. They are found to be in possession. They have traced to the property. There is no question of malpractice in my matter of obtaining Aadhaar. That is the finding recorded by investigating authority. All these documents were made available. And having observed that these documents are made available, this divisional authority has failed to record any finding on those documents.
Yes.
Only on two grounds. Forward is not produced. And the derivation of taking the Putta cannot be traced by me. Go back to the street. This could not have been paid. My expectation. This started to write. But how I am.
ಮತ್ತೆ ಅದೇ ರಿಪೀಟ್ ಮಾಡ್ತೀರಾ ಎಷ್ಟೊತ್ತಿ ಅಂತ ರಿಪೀಟ್ ಮಾಡ್ತೀರಾ One 1685. Yes. Yes.
You are reiterate as to what is the company and they are directly going to these 8 strips of land which they claim to have been transferred by the signature. Those 8 strips of land which commence the paying of marking cost.
Yes.
But I read out this thing with relation to
40 is Tumpur.
page number 40 is Nishimoto area company.
40 is Tumpur.
I'm reading the original not the
Type
right
1.
copy. It is 40 cross page.
Shimoga starts from 48. Type copy starts at 108. The original starts at 48.
The comparison with respect to the statement of objection not is filed by respond number 4, not the banking code, page number 54.
In the same petition.
In the same petition.
Respond number 4, ಯಾವ file ಮಾಡಬೇಕು ಅಂದ್ರೆ
Statement of objection 2, one is the image map.
ಅಲ್ಲಿಗೆ
Page 53 not.
No, it's not here. I'm not sure. Make sure.
It says, till page 53.
R10.
Yes, page 53.
Yes.
Not in middle, Rama Kalhadi. Rama Kalhadi. ಕೆಳಗೆ ರೋಮನ್ 150.
ಮೇಲ್ ಇದೆ ಗ್ರಾಮ ಕಲ್ಲಡ. ಎಸ್ ಅದು ನೀವು ಬರ್ದಿದ್ದೀರಾ, ನೀವು ಯಾರೋ ಬರ್ದಿದ್ದೀರಾ.
Next page. Next document.
R11.
Yes. The entire layout marked in square blocks. But it's not. After the right side, we are going to put a triangle. Also read it as the two house road.
Yes.
Which leads to the triangle, that is S2.
Yes.
The water portion is the middle portion is S3 in the S8.
How the?
What's the kindly not come to the speed of invention? Bounded by S1, not the main road. S1 if it is taken as the road.
North ಎಲ್ಲಿದೆ ಇದು?
On the left hand side, the road is going to be there. Left hand side bottom indicated north.
North. North is the main road. Yes.
How to make an office? After this, the previous.
Megram ಅಂತಿದೆ. Not Megan ಇಲ್ಲ. ಹೆಸರೇ ಚೇಂಜ್ ಆಗುತ್ತೆ. With the same hospital. EARM ಅಂತ ಆಗೋಗಿದೆ.
Best place survey number 20 and 16.
South by Megan Hospital.
Yes, in all together.
West by 20. East by ಎಲ್ಲಿದೆ?
East by
East by
balancing the tank road.
Balancing tank.
The right side are also coming. Annexure area.
Balancing tank. Yes.
Interesting, not to come to two. Yes, two. Individual road. Other schedule. Not the circuit also. The intention of the annexure R11. Not so many.
South by Mission side sold out.
These are the sections are there.
Who was it sold?
They have sold it out. We have no information on that.
There must be some records available with. So who is there in this property now? Who is there in the sold property? The circuit house road south ಗೆ sites have been formed.
Each and every site which is now mentioned in the deed of indenture, from S1 to SA, the schedule matches in the village map. Now, our case is that the land which is now been identified for
We come back to S1. Shumaga district, Durgigudi extension, Shumaga. Shumaga SRO. Mission Bungalow B6, Ladies Bungalow, Evangelist House 632. Caretakers quarters and car shed 634. Now, if you stay north by main road and south by main road, Megan Hospital, west by and east by Balancing Tank Road, that means S3, S4, S5, S6, S7 and S8 ಎಲ್ಲಿಗೆ ಬರುತ್ತೆ? It's part of S1. So it will be part of S1.
Except S2, S3, A form part of S1.
Why should there be a separate description?
That is what confusing us. Because 8.1, I just made a small measurement. Just pass this.
Let's ask you this. This site number 1 to number sari illa idu. 1 to 23 ಬರುತ್ತೆ first.
1 to 9 ಇದೆ. 1 to 23 starts at 48.
48 to 60.
Maybe continue to the right hand side, which is not after this road works.
ಆಮೇಲೆ ಕೆಳಗೆ 28 ಇಂದ 27 ಇಂದ ಇದೆ. 22, 23, 24, 25, 26. ಹಿಂಗ್ ಹೋಗ್ಬಿಟ್ಟು ಹಿಂಗ್ ಬಂದು ಹಿಂಗೆ. This is the maze. Okay. So this side, this whole thing of 1 to 86. What is the extent of that land? This box.
47, 4,77,500.
Including the roads. Including the roads.
Yes, I just passed it.
And where do you, which is the subject property?
Subject property in the water portion in the bank.
That is where the balancing tank is.
F1 is the actually Megan Hospital road ಅಂತ ನೋಡಿದ್ರು.
That is reservoir in the ಹೋಗತ್ತಲ್ಲ ಅಲ್ಲಿ ಬರುತ್ತೆ. Where is the convention center located? So give us one plan with all the things.
We understand what say water not is very deep. Hospital is not supposed to be constructed.
Yes.
Establish as schedule what is known as the signature pertains to these sites which have nothing to do with the property which is already proposed to for construction of. Maybe of a little
Produce ಮಾಡಿದ್ದೀರಾ? At 10. Block 1 to block 5.
Yes, it corresponds with the Roman 1 to 3 for what we have indicated.
Yes.
Block number 1. Shimoga, Uday, and the Dava.
US ಇಂದ 10 judges ಕೋರ್ಟ್ ಹಾಲಿಗೆ ಬಂದಿದ್ದಾರೆ. US 10 judges. ಅದಕ್ಕೆ ಜಾಗ ಎಲ್ಲ
Yes.
That is pertaining to S2.
Block 1 is pertaining to S2.
Yes.
Yes.
Block 2, are you going to get this Thomas somewhere on 19 years, happy more better.
That is 3,18,211 square feet. The block 1 is 4,40,000.
Yes.
Yes.
Block 3 is case interest. Upstairs, Mr.
That is 2 acres 35.
Yes, that is on the left hand side, down the behalf.
So according to you, block 1 and block 2 are not being disturbed. And block 1 and block 2 are 7,58,000 square feet approximately. That will make it 75. Makes it nearly 17 acres. 17 acres it makes.
That's the reason it's in the paper of objection. We are saying that where owners claim to be their documents are allowed. But by whatever reason, they are in possession of 18 acres as per our part.
And that is not being disturbed.
That is not disturbed. We have nothing to do with that. Second thing, we are coming to other side. The other trend is now indicating that there is a spook and an away which has now attained penalty. Just go back to that. But they are not going to do that. Not trying to permit it.
In which petition? One? Page number? One 194, Mr. Van Prakash.
The next series starts at 175.
This is the type copy of the judgment
Yes.
in RA 101.
Yes.
Yes.
The first paragraph, statements of interest in person in respect of property described in the statement comprising a plot of land indicated in the plain state by letters CTE of the part of the for AC and line is the properties are offsetting. The east is shown as municipal land to the municipal land. The west is stated that to north circuit house and south vacant land of the land. So what is the land it comprises which is disputed will not find in the next paragraph.
So east is shown as municipal land. So your part 4
Yes.
is on the east.
Yes, sir. West is shown by
So you paid this land. North is the circuit house and now circuit house road. Megan Hospital.
next paragraph. 80 colleges, 86 grand measures, 275 yards to the north, 375 to south, 50 yards to the east and so on. This appears to be almost in the rectangle of the supply. He claims that software was granted to and is in possession and sell the sites abutting to the balance land. And 20 get think is no red measured as one. Area of 14 is less than 290 watts is attempted before the use file. This is the declaration which is not the owner of the land.
Either testimony is 14 east, 14 feet and
East to west.
295 yards. He is part of block 1.
Yes. Our declaration is only so far as this. You want to kindly confirm the entire judgment, not take a lot of time to read the judgment. So the judgment is indicating on the fact that the commissioner was appointed, probably in the suit proceedings. Commissioner also would indicate the same. The commissioners think even though they have disputed, lots would kindly come to page 245, para 16. Do not say page 16, para 16.
Yeah.
According to the commissioner, there has been enforcement of 8 things back. Despite the fact that the defendant has dismissed the characters of the commissioner's question. Order by the state to abide on all the state to abide the funding was not found out. Not because the change of fund to 2.3. Continuous plots in the last 3 lines. It might be that the plaintiff not to the court as the street is not 14 feet of 14 feet wide ship 90 yards. Yards long. But after that, it is not in it was described. The last here.
Yes.
They have got 70 of the now they is to the 8 feet strip. Apostrophe would indicate one apostrophe as a two. Have been established. As it is a piece of vacant land, the possession of state, there can be no dispute about this land. Not as a dependent people, but when the advance of the PO. The land concept also has directly helped from the that comes to play in the it would not possible to indicate the correct relation of the then both the parties on the other hand, because in several of the there's not been substantiated in any manner. Then the order was more controlled. The order will indicate
to balancing tank road and was stopped from disputing it.
the state is stop to find out correct location.
Plaintiff is declared owner of 8 feet strip of area. Because that was the only thing disputed on Thursday.
Last question, they are declared owner of the
Be honest, we're also very be honest.
Normally, area which I now shown us and area which we are so not content that we are not take over some land not by the intention which he now claims to have what right and right over the property. It indicates sketches in the village work is indicating of the fact that further away from the area which is proposed to be given purpose for transaction.
Mr. Basraj, from a reading of this, what we subject to what you say, the impression that we are getting on this schedule is that the description of S1 is like Schedule A property. S2 to S8 are part of Schedule 8 property, which have been retained. But from what? Because you have given the site measurements, which are matching with that plan. If you had entire S1, then the question of describing S2 to S8 separately would not arise. You had that entire land, you formed 86 sites, you sold 80, you sold whatever 78 sites to other people. You have retained 8 sites, and those are with you.
The layout plan, not the, this one strips which they are earmarked. It was not found in the layout plan. It is, they have only marked. Sorry, this one. In fact, I was stated showing a statement of objection. This one, what they have indicated in the layout plan is not found in exhibit P9. Then you take exhibit P9.
Tell the P9.
Exhibit R11.
R11. Yes.
Yes, one you mark for the 8. It's not found in the original layout plan. I have produced that document along with the design.
Where is the original layout plan?
I have produced it, sir. I have produced my design. Not there. Sir, result in 1686.
16?
86. Page number 8. September
7 September?
2020.
Again.
1686.
16866.
Okay.
7 September. 7 September. Next year?
Page number.
Page number? Page number?
8.
ಅಲ್ಲ ಅವ್ರು ಮಾರ್ಕಿಂಗ್ ಮಾಡಿದ್ದಾರೆ. So now this is your plan.
Yes.
Admitted by you.
Yes, sir.
Now we come to your intervention. Page 48.
In fact, going by their own document, R10 minutes, they say that S1 is part of.
Namgu Godila, we are trying to find out what is this.
They are going to contend that S3 to S8 are a part of S1. If that is to be accepted, not change into their own document, exhibit R10.
You now come to page 48.
Page 48 of
your indenture. ಈ ಪ್ಲಾನ್ ಇಟ್ಕೊಳ್ಳಿ, ಅದರಲ್ಲಿ ಅದು ಇಟ್ಕೊಳ್ಳಿ. Yes. 48 is S2.
48 is yes. Starts from Shimoga area comes S1.
Yes.
First property.
49 is ಬನ್ನಿ ಇವರು. S3 ಬನ್ನಿ.
S3.
49.
North by conservancy now.
South by main road.
Main road.
East by
East by
83.
site number
38. West by main road. Now this is site number 39. Right hand side corner ಅಲ್ಲಿ ಇದೆ ನೋಡಿ. Shimoga SRO site number 39.
The Rashid is find out from the plan layout.
Yes, speaking of that.
Site number 39.
So this is site number 39. East is by site number 38.
This document is of your 80s.
That is your base document.
I'm
So now you come to this.
This layout plan card, this is late the 90s. Yes.
Now you come to this, Mr. Bhaskar. This is admitted, Allah.
Oh,
One.
the mark document in the school.
Where is this site number 39? Last row ಅಲ್ಲಿ ಇದೆ ನೋಡಿ. 39 ಇದೆಯಾ?
Yes.
ಅದರ ಪಕ್ಕದಲ್ಲಿ 40 ಇದೆಯಾ? 40 is S4.
40 is S4.
41 is S5 and it's available here also. Then you come to S6,
Yes.
site number 80. That comes in the third row.
Yes.
West by 82, east by 79. Next one is 81. West by 82. And 82, west by 83, east by 81. So that is a block there. This is what you seem to have retained. If you look at S1, is this entire extent of land. North by Main Road, south by Megan, survey number this one, balancing tank road, is the entire land. You retained only this one. You sold the rest of it, and those sites, constructions ಆಗಿದೆಯಾ? Mr. Gangadharappa would have to say. Construction ಆಗಿದೆಯಾ vacant? ಇವರು ಮುನ್ಸಿಪಾಲಿಟಿ ಯಾರಿಗೂ ಏನು ಗೊತ್ತಿಲ್ಲ ಇದು. Who is the purchaser? What has happened to it?
You all according to them, what they want in the plan. Just one yesterday. That is also not conforming to the plan to be sanctioned.
That is in conformity with this annexure M that you have produced. I think you cannot say it's not in conformity. It is in conformity.
What's later could be the execution of the transfer deed. But then there was no sanction of this plan.
When was this plan sanctioned? That's marked in those proceedings. Yes, Mr. Yes, that we have seen.
Yes, that is what is indicative of P9.
Yes.
In the year everything. Not as per it is not subsequent to the deed of indenture is to that. Third point is, now
The question is whether that was sanctioned prior to the indenture or not. But since the reference is made clearly in the indenture as regards that, and there is admission by you, that is the exhibit P9. So that matches with it, and then we'll have to draw the only inference
Kindly go to page 210 of the resolution.
210.
Yes. Everything is equal.
Yes.
The appellant amendment appears to be the court of Supreme Court from the degree of the Supreme Court in 135-59. If we take the this plan, we will find the case number of
It will be 9.
yes.
There can't be any dispute on that.
Therefore, this document is not they are making very.
They have indicated yes, no, yes, to yes, three. Their statement of okay. Contrary to one which is found in the exhibit.
That is not contrary, Mr. Vestergaard. It is not at all contrary. It is perfectly matching. It's perfectly matching. And this was marked by your predecessor in interest in the suit. Your predecessor in interest. And the way that, that's why we asked you where are the documents, title deeds of these documents prior to your predecessor. How did your predecessor get it? Those are not there on record. Your predecessor has got S1 and he has formed this layout.
Their criticism got denied.
Now you can't question it after 60 years or 70 years. Much before both of us were born, so leave it at that.
Third important aspect is the reason indicated in the income law is that they are intending to have a capital. In the entire neighboring district, including the district of Karnataka, no capital. For this, they have come down to Bangalore.
Whatever laudable purpose it may be, it has to be in accordance with law. So far as
Presuming that I have convinced not to say that these lines which are now indicated by me are separately situated and that will be claim made to the distance here. The reason why we have to come out, the reason why we are wanting this line is to put up the non-specific position. That reason. Second matter also. Only one second.
Second matter is not with respect of the disputed property alone. It is in respect of the entire property, in respect of which the petitioner holds obligation.
where is the Tata in your favor?
And it is not in dispute. I have to do all the other.
What is the extent in your Tata?
Commencing from blood. Page 132. The petition 16,008.
Yes.
These are the Tatas I hold in my name.
What is the extent, Mr.
It is also mentioned. The 10 copies are available.
Sixty plus 65 by 2.
Yes, yes.
194 plus 194 by 2.
Yes.
111 plus 111 by 2. And 60. These are all sides.
So I have paid the taxes are also collected.
Where have you paid? Well, actually, what you are saying is you are the owner of 4 lakh and odd, 11 acres and odd.
Yes.
Where does it say that you are paid for 11 acres? 4 lakh 45,000 square feet, lekka elbara.
Yes. The taxes are being paid.
Lekka torsi 4 lakh 45,000.
We all the extracts are good. Assessment extracts are.
Total of Madi, ಎಷ್ಟು ಬರುತ್ತೆ ಅಂತ ಬರಲ್ಲ ಅಲ್ಲಿ. What we are seeing here, these are all those S2 to S8, those sites. Our site measurement is there.
First petition blood. They were not passed by the deputy commissioner of blood.
Yes.
to enter, not to deal with the properties and directing the authorities to enter the disputed property. In that context, not the review petition was filed before the reviewing authority said that no, you cannot no, I have only passed this order and come out with data because somebody else has filed the revision petition. So this is a challenge before the Supreme. And the Supreme Court found that the petitioners in the writ petition or the representatives of the Church of India, they were not heard in the matter and remanded the matter to hear them and pass authority. The regional authority what's that? Now go back to the petition.
That is what we'll also be saying. You will have to establish your title from what documents you have produced and what you have shown us.
There's already a decree made, right?
That decree is only for 8 feet. It's only for 8 feet. On the basis of a decree of 8 feet, you are now seeking to lay a claim on 4,45,000 square feet.
The fact that apart from the one S1 which they are claiming as a disputed property, the other property where I hold Tata, it is not disputed with the corporation.
That is not what they're disturbing also is what they're saying. It's only block 4.
Block 4, my last one content, block 4. Block 4 is
content madam. Content new madam.
Sorry.
Yes.
So I like to hold that the disputed property is beyond the property which is person in land. With respect to other properties, I lawfully hold Tata. The authorities cannot pass on the improved order. The record is pointing that I have not followed on or not, despite the fact that they were going to request and no such defense was taken to or before the reviewing authority. And the authority having record of finding that there is already a decree in the favor. Again, go back to the dispute court. So the recording of finding that whether on the basis of the documents where Tata is protected is bad. That is not the finding of the legal authority.
We'll deal with that.
The CID has made an observation that it is our property. And the corporation, the commission itself records a finding that it is the property of India.
For S2 to S8.
Yes.
There's no problem about S2 to S8.
16,866. I have challenged the art of the regional authority.
Your claim is only S2 to S8 as per the indenture. Whatever the measurement of S2 to S8 is there, they cannot disturb it.
Yes, of course, there are no limits.
Yeah, that's 2 kilometers away is what it is. The S2 to S8 is the only issue. That will direct them not to do it. Anyway, that is their own submission that they are not bothered about S2 to S8. They're not concerned about it.
The statement of objections, but the category to include the time portion of entire of this properties.
It is as we'll deal with it. You are getting better. Yes, Mr. Kalar.
Tata Express. They are starting from page 132 onwards. They are all waiting, but just standing. Not interested in that money, asking money, type money.
Community holiday.
Our site or ಇಟ್ಕೊಂಡಿದ್ರು ಅದರ ಮೇಲೆ ಏನು ಕಟ್ಟಿದಾರೋ ಅದು ನೀವು ಯು ಆರ್ ನಾಟ್ ಡಿಸ್ಟರ್ಬ್. For the argument of Shri Kalyan Basraj, Learned Counsel for the petitioner, Shri Bhanuprakash, Viji Bhanuprakash, Learned Additional Advocate General, Shri A.V. Gangadharappa, reserved. Rajan.
230 madam.
230 madam. Page 19. Yes.
Second respondent authority, the third respondent, the compensation. Take disciplinary action.
Yes. on 187 and no proceedings have been initiated. The 187 notice you will issue. Either 64. ಅಲ್ಲ ಯಾವ್ದ್ರಲ್ಲಿ ಬರುತ್ತೆ ನೋಟಿಸ್ ಇದು 64
ಈಗ
ನಿಮ್ ಸಬ್ಮಿಷನ್ 64 ಅಲ್ಲಿ ಇಶ್ಯೂ ಮಾಡ್ತೀರಾ ಅದುವರೆಗೂ ಏನು ಮಾಡಲ್ಲ ವಿಲ್ ರೆಕಾರ್ಡ್ ದಟ್ ಸಬ್ಮಿಷನ್.
To show cause as to why action should not be taken against the third respondent, my lord, for not taking action for violation of the hearing. That may not show cause for this, that not be made. Therefore, virtually, my lord, it is an order directing the third respondent to give the demolition.
You get the instruction. Then AGA accepts notice for respond number 1. Sri Vijay Somyaji accepts notice for respond number 2 and 3. The operation of the order dated 4/9/2023 issued by second respondent at Annex A is stayed till the next date of hearing. ನೀವು ಫೈಂಡ್ ಔಟ್ ಮಾಡೋದು ಹೇಳಿ ನಮ್ಮ ವಕಾಲತ್ನಾಮ ಹಾಕ್ಬಿಟ್ಟು ಹೇಳಿ how will record it. ಇವಾಗ ವಕಾಲತ್ನಾಮ ಇಲ್ಲ ಎಲ್ಲ ಯಾಕೆ ವೈ on 31st October. 31st October. Upload ಆಗುತ್ತೆ ಇನ್ನೇನಿದೆಯಾ? We'll have to have it on another day. All of them took a lot of time. Monday whole idea. Tuesday. Today we cannot uncover them. It will come up. We have to raise for the. Yes. We don't have the file. Date.
Court officer.
Court officer.
54th matter.
Court officers. 60.
ಸಿ ವೇಟ್ ಮಾಡಿ ಅಲ್ಲಿ ಮುಗಿಸ್ಕೊಂಡ್ ಬರ್ತಾರೆ ಫಿಸಿಕಲಿ ಡೇಟ್ ಕೊಡ್ತಾರೆ. ವೇಟ್ ಮಾಡಿ
ಸರ್ 54th ಮ್ಯಾಟರ್.
ವೇಟ್ ಮಾಡಿ ಸರ್, ವೇಟ್ ಮಾಡಿ ಬರ್ತಾರೆ. ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
ಓಕೆ.
ಫ್ಯಾನ್ ಲೈಟ್ ಇರ್ಲಿ, ಬರೀ AC
ಮಂಡೇ ಇಲ್ಲ, ಟ್ಯೂಸ್ಡೇ ಬೇಡ.
Serial number 69.
Consider representation is there.
63 ಮೇಡಮ್ 63 ನೀವೇ ಡೇಟ್ ಹೇಳ್ಬಿಟ್ರೆ ಒಂದೊಂದ ಕರೆದು ಸುಮ್ಮನೆ
ನವೆಂಬರ್ 9ನೇ ತಾರೀಕು.
Serial number 69, madam, court officer.
63 ಮೇಡಮ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ 63
ವೇಟ್ ಮಾಡಿ ಬರ್ತಾರೆ.
ಡೇಟ್ ಕೇಳ್ದವ್ರಿಗೆಲ್ಲ ಹೇಳ್ತಾವ್ರೆ, ಯಾರ ಮಾತು ಕೇಳ್ಬೇಕು ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ ನಮ್ಗೆ.
Court officer, serial number 69.
ಒಬ್ಬ ದಸ್ತಗೀರ್ ಸಾಹೇಬ್ರವರು ಕರೆಕ್ಟಾ?
ಇದು ಉತ್ತರಳ್ಳಿ ತಾಲೂಕು, ಉತ್ತರಳ್ಳಿ ಅಲ್ಲ, ಉತ್ತರ ತಾಲೂಕು, ಬೆಂಗಳೂರು ಉತ್ತರ ತಾಲೂಕು, ಉರುಳಿ ಚಿಕ್ಕನಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ. ಒಬ್ಬ ದಸ್ತಗೀರ್ ಸಾಹೇಬ ಎಂಬುವರು ಬೆಂಗಳೂರು ಉತ್ತರ ತಾಲೂಕು ಉರುಳಿ ಚಿಕ್ಕನಹಳ್ಳಿ ಸರ್ವೆ ನಂಬರ್ 15 ಗುಂಟೆ ಜಮೀನು ಬೈಲ ಹನುಮಯ್ಯ ಬೀನ್ ಅಂಜನಪ್ಪರಿಂದ ಶುದ್ಧ ಕ್ರಯಕ್ಕೆ ಪಡೆದು ಅವರು ಸ್ವಾಧೀನಾನುಭವದಲ್ಲಿರುತ್ತಾರೆ. ಸದರಿ ದಸ್ತಗೀರ್ ಸಾಹೇಬ್ರವರು 10/4/2000 ನಿಧನರಾಗಿರುತ್ತಾರೆ. ಸದರಿ ದಸ್ತಗೀರ್ ಸಾಹೇಬರು ನಿಧನರಾದ ಮೇಲೆ ಅವರ ಧರ್ಮಪತ್ನಿಯಾದ ಖಾತೂನಾ ಬಿ ಅವರ ಹೆಸರಿನಲ್ಲಿ ಸರ್ವೆ 15 ಗುಂಟೆ ಜಮೀನು ಖಾತೆ ಬದಲಾವಣೆಯಾಗಿರುತ್ತದೆ. ಹೀಗೆ ಅವರ ಮರಣಾನಂತರ ಮಾಲೀಕತ್ವ ಪಡೆದ ಖಾತೂನಾ ಬಿ ಮತ್ತು ಅವರ ಮಕ್ಕಳಾದ 1ನೇ ಅಬ್ದುಲ್ ಕ್ಲಿಯರ್ ಮಾಡ್ಬೇಕು.
ಇವತ್ತು ಅಶೋಕ ಆರಾಧ್ಯದು ಜಡ್ಜ್ಮೆಂಟ್
ಹೋಗಿ ನೋಡ್ಕೊ ಬರ್ರಿ. ಹೋಗಿ ಬೇಗ ಬನ್ನಿ. ಸ್ಕೂಟರ್ ತಗೊಂಡೋಗ್ತೀರಾ? ಯಾಕೆ ಓಡ್ಸಕ್ ಬರಲ್ವಾ? ಎಷ್ಟು ಮಾತಾಡಿತಿ? ಅವ್ರು ಓಡಿಸ್ತಾರೆ, ಅವರು ಕರ್ಕೊಂಡು ತಗೊಂಡೋಗಿ ಕೇಳಿ ಓಡಿಸ್ತಾರ. ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 63 ಮೇಡಮ್
63.
ಹಾ
ಸರ್ ಯಾವತ್ತಿಗೆ ಬೇಕದು?
ಯಾವತ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಯಾವತ್ತಾರು ಒಂದು ಡೇಟ್ ಕೊಡಿ ಮೇಡಮ್.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಎಲ್ಲ ಹಿಂಗೆ ಸರ್ ರೀಚೇ ಆಗೋದಿಲ್ಲ, ಅದಕ್ಕೆ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಅಂತ ಆಗ್ಬೋದಾ?
ಹೇಳಿದ ಮೇಲೆ ಆಯ್ತು.
6/11 ಒಂದ್ ತಿಂಗಳು ಕರೆಕ್ಟ್ ಆಗಿ
25ನೇ ತಾರೀಕು ಹಾಕಿ ಮೇಡಮ್. ಏನಾದ್ರೆ
25 ಆಯ್ತು ಸರ್, 25ಕ್ಕೆ ಹಾಕ್ತೀನಿ ಸರ್.
ಹಾ ಆಗ್ಲಿ ಮೇಡಮ್, ಥ್ಯಾಂಕ್ ಯು.
ಆಮೇಲೆ ಸರ್
ನಂಬರ್ 82
ಮೇಡಮ್ ಅದ್ರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಐತೋ ಇಲ್ಲ ಸರಿಯಾಗಿ ಗೊತ್ತಿಲ್ಲ, ಒಂದ್ ಸ್ವಲ್ಪ ಚೆಕ್
ಅಲ್ಲ, ನಾನ್
ಮಾಡ್ಕೊಂಡು.
ಫೈಲ್ ಚೆಕ್ ಮಾಡೇ ಮಾಡ್ಸೋದ್ ಬಿಡಿ ಇದ್ರೆ.
ಸರಿ ಮೇಡಮ್,
ಯಾವ
ಸರಿ
ಡೇಟ್
ಮೇಡಮ್.
ಬೇಕದು? 82
ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಯಾವ್ದಾರ ಹಾಕೊಡಿ ಮೇಡಮ್.
6/11
ಪ್ಲೀಸ್ ಪ್ಲೀಸ್
ಮೇಡಮ್. ಸೀರಿಯಲ್ ನಂಬರ್
79 ಯಾವತ್ ಬೇಕು ಸರ್ ಅದು?
70 ಮೇಡಮ್ 70
ಯಾವತ್ತಿಗೆ ಬೇಕು ಸರ್ ಅದು?
ಯಾವಾಗ ರೀಚ್ ಆಗುತ್ತೆ ಅವಾಗ ಹಾಕಿ
ಇಲ್ಲ
ಮೇಡಮ್.
ಅದು ಬೆಳಗ್ಗೆ ಬೆಳಗ್ಗೆನೆ ಟೈಮ್ ತಗೊಂಡ್ರಲ್ಲ ಸರ್ ಅದು 70 10:30ಗೆ 7/11 ಅಂತ ಆಗಿದೆ. ಬೆಳಗ್ಗೆನೆ ಟೈಮ್ ತಗೊಂಡ್ರು.
7/11 ಆಗಲ್ಲ ಮೇಡಮ್, ನಮ್ಗೆ ಆಗಲ್ಲ 7/11ಗೆ. ನಮ್ಗೇನು ಇನ್ಫಾರ್ಮ್ ಮಾಡಿಲ್ಲ.
ಬೆಳಗ್ಗೆ ನಾನು ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದೀನಿ ಅಂತಾನೆ ಹೇಳಿ ಟೈಮ್ ತಗೊಂಡ್ರು.
ಇಲ್ಲ ಮೇಡಮ್, ನನ್ಗೇನು ಇನ್ಫಾರ್ಮ್ ಮಾಡಿಲ್ಲ. ನಾನು ಇಲ್ಲೇ ಇದ್ದೀನಿ, ವೇಟ್ ಬೇಕು ಇದಕ್ಕೂ ಬಂದಿದ್ದೆ ನಾನು.
2 and 3 ಅವ್ರು ತಗೊಂಡಿದ್ದು ಟೈಮು.
ಇಲ್ಲ ಮೇಡಮ್, ನಾನು 7/11 ಆಗಲ್ಲ.
ಇಲ್ಲ ಅದ್ ಬರ್ದ ಆಗೋಗಿದೆ ಬಿಡಿ. ಬೆಳಗ್ಗೆ 10:00 ಆಗಿದ್ದಲ್ವಾ, ಸೈನು ಆಗೋಗಿರುತ್ತೆ ಇಷ್ಟೊತ್ತಿಗೆ.
ಅಲ್ಲ, ನಮ್ಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡ್ದಾನೆ ಹೆಂಗ್ ತಗೊಂತಾರೆ ಮೇಡಮ್?
ಕೇಳಿದಕ್ಕೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದೀನಿ ಅಂತ ಹೇಳಿದ್ರು.
ಸುಳ್ಳು ಮೇಡಮ್, ಅದು ಇದೇ ಮಾಡೋದು ಕೆಲಸ ಅವರು. ಬರೀ ಇದಾಗಿದೆ ನನ್ಗೆ
ಅಷ್ಟೇ. ಈಗ 7/11 ಬರುತ್ತೆ ಸರ್, ಅದಕ್ ಮುಂಚೆ ಬೇಕಂದ್ರೆ ಮೆಮೊ ಹಾಕೊಳ್ಳಿ.
ಮುಂಚೆ ಬೇಡ ಮೇಡಮ್, ಅವತ್ತಿನ ದಿವಸ ಬೇಡ ಅಷ್ಟೇ. ಅದಾದ್ಮೇಲೆ ಯಾವತ್ತು
ಅದೇ ಅವತ್ ಬಂದಾಗ ಆಗುತ್ತೆ ಬಿಡಿ ಅಷ್ಟೇ.
ಅಲ್ಲ ಮೇಡಮ್
ಯಾಕಂದ್ರೆ
ಮತ್ತೆ ಆಮೇಲೆ
ಬೆಳಗ್ಗೆನೆ ಆಗೋಗಿದೆ, ಈಗ ನಾನ್ ಕೊಡೋದಲ್ಲ ಅದು.
ಅಲ್ಲ ಇದು
ಯಾವ್ದು
ನೋಡಿ, ಅಲ್ಲ
ಉಳ್ಕೊಂಡಿದೆ
ನೀವು
ಅದ್ ಮಾತ್ರ
ಇಲ್ಲ
ನಾನ್
ಮೇಡಮ್ ಅದು ನೋಟ್ ಮಾಡಿ, ಅವರು ಸುಳ್ಳು ಹೇಳಿದ್ದಾರೆ ನಮ್ಗೆ ಹೇಳಿಲ್ಲ ಅದು, ನನ್ಗೆ ಅದನ್ನು ಪ್ಲೀಸ್ ನೋಟ್ ಮಾಡಿ.
ಅಷ್ಟೇ ಸರ್. ಬೇರೆ ಇನ್ಯಾರು?
ಮೇಡಮ್ ಅದು 69 ಸೀರಿಯಲ್ ನಂಬರ್
69.
ಅದು ನಾವು NOC ವಕಾಲತ್ ಹಾಕಿದ್ದೀವಿ, ಆದ್ರೆ ನಮ್ದು
ಅದೇ ನೀವ್ ಹೆಸರು ತೋರಿಸ್ಲಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದ್ರಿ. ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಬರುವಾಗ ಹೆಸರು ಬರುತ್ತೆ ಸರ್. ಯಾವತ್ತಿಗೆ ಬೇಕು? ನಾನು ಅದ್ ನೋಟ್ ಬರ್ದಾಕ್ತೀನಿ. ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಬರುತ್ತೆ ಯಾವತ್ತು.
ಬರ್ಲಿ, ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಬರ್ಲಿ.
ಆಫ್ಟರ್ ವೆಕೇಶನ್ 8/11 ಸರ್. ಅದು ಅವರು ಪಿಟಿಷನರ್ ಟೈಮ್ ತಗೊಂಡಿದ್ದಾರೆ.
ಯಾವ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ?
8/11.
ಓಕೆ
8 ನವೆಂಬರ್.
ಅದೇ ನಮ್ದು ಕಾಸ್ ಲಿಸ್ಟ್ ಬಂದ್ರೆ ಸಾಕು, ನಮ್ಮ ಹೆಸರು.
ಅದೇ ನನ್ನ ನೋಟ್ ಒಂದ್ ಬರ್ದಾಕ್ತೀನಿ ಫೈಲ್ ಅಲ್ಲಿ, ಅವಾಗ ಲಿಸ್ಟ್ ಆಗುತ್ತೆ, ಅದು ಬರುತ್ತೆ ನಿಮ್ಗೆ. ಆಮೇಲೆ ಸರ್ ಇನ್ಯಾರು? ರಾಜೇಶ್ ಸರ್ ಯಾವತ್ತು?
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 72 ಯಾವತ್ತು ಹೋಯ್ತು ಮೇಡಮ್? ಹಲೋ
ಹೇಳಿ ಮೇಡಮ್.
72
ಯಾವತ್ ಬೇಕು ಮೇಡಮ್ ಅದು?
ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಹೋಗ್ಲಿ ಬಿಡಿ ಮೇಡಮ್. ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಹೋಗ್ಲಿ.
7th ನವೆಂಬರ್.
ಆಯ್ತು ಮೇಡಮ್, ಥ್ಯಾಂಕ್ ಯು.
ಅಷ್ಟೇನಾ? ಇನ್ನು ರಾಜೇಶ್ ಸರ್ ನಿಮ್ದು ಯಾವ್ದು?
ಹಲೋ ಹಲೋ
ಡೇಟ್ ಕೊಡ್ತೀನಿ ಆಮೇಲೆ ಅಪ್ಡೇಟ್ ಆಗ್ತದೆ.
ಮೇಡಮ್ 54
ಹೇಳಿ
31st ಆಗುತ್ತೆ ಮ್ಯಾಮ್.
31st ಹಾಕೋದಾ? ಸೀರಿಯಲ್ ನಂಬರ್ 54
ಹೌದು ಮೇಡಮ್.
ಸರಿ ಸರ್, 31st ಹಾಕುತ್ತೆ ಸರ್.
ಓಕೆ.
ಹೆಣ್ಮಕ್ಳ ಹೆಸರೆಲ್ಲ ತಿಳ್ಕೊಳಕ್ ಭಯ, ಸುಮ್ಮನಿರಮ್ಮ. ಅದೇನೋ ಪಾಪ ಬೈತೀರಾ ಅವ್ರನ್ನ. ನಿಮ್ ಹೆಸರೇನು ಅಂತ ಕೇಳಕ್ ಆಗುತ್ತ ಅವ್ರು ಬಂದು? ಇಲ್ಲ, ಅವ್ರು ಬರೆಯಕ್ಕೆ ಬರಲ್ಲ.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ 84 ಇಂಟರ್ವ್ಯೂ ಆರ್ಡರ್ ಇದೆ, ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಗ್ಬೇಕಿತ್ತು.
ಹಾ ಸರ್ ಆಗುತ್ತೆ.
ಓಕೆ ಮೇಡಮ್, ಓಕೆ. 84 ಸೀರಿಯಲ್
ಯಾವತ್ತಿಗೆ ಬೇಕು ಸರ್ ಅದು?
ಆಫ್ಟರ್ ವೆಕೇಶನ್ 30th ಮೇಲೆ ಹಾಕ್ಸಿ ಮೇಡಮ್, ಪರವಾಗಿಲ್ಲ.
7th November.
7th November. ಓಕೆ ಮೇಡಮ್, ಓಕೆ ಥ್ಯಾಂಕ್ಸ್.